Back on House File 402, we have in front of us the proposed A1 amendment. To that, members, you have received additional amendment, the A2 amendment, proposing to amend the A1 amendment. Ms. Conklin, can you tell us what the A2 amendment does?
Yes, thank you, Mr. Chair. So the A2 amendment makes a couple of technical changes and a couple of clarifications in line with the AG's existing authority. There were a couple of spots where we were concerned that we were being newly empowered to do things that we don't do. So we have reined some of those back in with this amendment. So on the first page of the amendment, some of these are just clarification of language. So a person is exchanged for a healthcare entity, kind of going down the line. I won't read each and every one of those to all of you. The amendment adds back language that this committee had previously adopted, which occurs in part within the state of Minnesota or involves the healthcare entity formed or licensed in Minnesota. Our office believes that isn't strictly necessary, that it is implicit that the AG does not get to cross state lines and start enforcing laws elsewhere, but we're happy to include that if others are happy. Let's see, at line 1.8, we're adding in the phrase relevant to evaluating the transaction, just to clarify that the scope of our additional requests need to be refined to evaluating the transaction. We thought that was implicit, but we thought, given some of the concerns of stakeholders, that we would make that an explicit limit. Let's see, the same is repeated again at 1.12. For 1.13 through 1.15.
You missed the Hart-Scott-Rodino.
I did. Would Senator Limmer be willing to explain that one to the committee? Would he yield?
Replacing Hart-Scott-Rodino with the reference to U.S.
Yeah, I don't know if that's any clearer, Mr. Chair, but it does make a reference. I, for one, didn't know what Hart-Scott-Rodino was. If I needed to look it up, a U.S. code reference would be better. I have one more suggestion, though, Mr. Chairman. On that particular line, I would suggest after the comma and the parentheses on 111 to put a reference of date on it as of, let's say, today's date. This provision of Title 15, Section 18A could be amended sometime in the future. A couple word differences sometime in the future, 5, 10 years down the road. And if we're truly going to make reference to the U.S. Code Title 15, Section 18A, it should be as of today's date.
Ms. Conti, what are your...
Ms. Conti, what are your thoughts regarding that proposal?
Mr. Chair and Senator Limmer, if that is a change that makes folks happy, I am in the happiness business today. We would accept that proposal.
My concern is that it would freeze in time this statute. And if there were valuable or relevant improvements made or changes made on the federal level, we would not benefit from that either.
Mr. Chair?
So, Senator Limmer.
It can also go the other way. There could be developed deficiencies in this area of law. And quite honestly, I think we should say what we mean what we say, and put today's date down, because there is a reference to a specific title under the U.S. Code as of today. So I think for clarity's sake, and I think it is all right to freeze this in time.
Ms. Primo.
Mr. Chair and members, just one one consideration for the committee. So if we go to the A1 on page 7, at lines 7.13 to 7.15, the reason for the reference to that federal law is that the same copies of those filings submitted pursuant to the Hart-Scott-Rodino Act would then be required to be sent to the AG. And so in some ways, perhaps maybe this is a little different than other statutes, where do you want the AG to continue to receive something pursuant to a law, a federal law that has then changed? Perhaps the filings are different for one reason or another, but now, because it's frozen in time, those same filings are still required by the healthcare entity to go to the AG's office. It's just a consideration for the committee.
So as a practical matter, if the organization is submitting documentation to the is it Federal Trade Commission, all they'd have to do is make a second set and send it to the Attorney General's office. But if we freeze the requirements and there are changes, then they're going to have to go through and figure out which pages can apply to which entity as well. I guess I've seen it in statute where they identify a date, but I'm a little uncomfortable with the notion of freezing it in time. And if the Attorney General's office turns out they don't need some of the documents, well, they can ignore them. I don't know, Ms. Conti?
Mr. Chair, the goal with this was for us to get information that is being already created, that is subject, related to what we're looking into, and to receive essentially the duplicate copy. So it is correct. If we freeze this in time, I imagine there might be one or two private practice lawyers around in this room today. That is extra billable time for someone to create a historical, anachronistic version of a Hart-Scott-Rodino report 10 years down the road. Either way, it will contain important information about a transaction that the AGO will appreciate receiving. But if the goal is to keep with the original intent, which was to just give us a copy of what is already submitted federally, then the year's reference will complicate that effort.
Mr. Chairman,
Senator Limmer.
despite the fact that the AG's office wants to be in the happy business, I'll withdraw my request.
Ms. Conti, please go ahead and proceed describing the A2 amendment.
Thank you, Mr. Chair. Thank you, Senator Limmer. So let's see. 1.13 to 1.15 is language around charitable assets receiving the full and fair value of those assets. So that is kind of standard language out of 317A. We are recognizing with this additional language that there may be some situations in which a discount to the full and fair value is in the public interest. And so we are preserving the flexibility for entities to make those decisions if they're doing so in the public interest and in line with their charitable missions. I will skip over a couple of minor nits that are here. Let's see. And then apologies, one of these pieces I think may have been an addition from someone else. This one.
I think no. Yeah, we just accepted it. I thought we.
Got it.
You had. The term change.
Oh, apologies. There we go. Sorry. So 1.22 to 1.24. So that's making a change on page 9. The language had, here we go, 31. Yes, so this is around the notion of a rebuttable presumption. So the earlier version of this amendment instructed the Attorney General and the District Court to kind of take on a presumption about a variety of things about the University of Minnesota. That is not traditionally how the legislature has done presumptions. The legislature will say there is a presumption, and then the court, goes forth and enforces it, but there's not really, the AGO doesn't, there's no way to operationalize our taking on of a presumption. So we have changed that language slightly to make it clear that those values are part of a presumption that exists in this version of the law, but it no longer is expressly directing the AGO or the district court to take on that presumption. So that is attempting to put this back into the more traditional form that it is done.
On that question, Ms. Conti.
On that question, Ms. Conti, maybe I'm just not reading this quite correctly, but it looks like on line 9.23, starting paragraph B, there's a clause 1 and 2. You're adding a clause 3, right?
That's, yes, so
And grammatically, on line 1.23, the amendment losing, it sounds like it should be lose, L-O-S-E, to have the verb in the proper tense.
So it should be losing because the earlier clauses have been technically corrected to say remaining and becoming. There were some subject-verb agreement
Oh, I
issues
see.
earlier, so those have been streamlined, and now for parallel structure.
Never mind.
We have that losing piece, and then the later language that bleeds over onto the top of page 10 is being stricken.
Got it. Thank you, Ms. Conti. Go ahead and proceed.
You're quite welcome. At 1.27, so there are some pages on, or changes on page 10, line 13. We are changing that language to reflect the House language. So currently this provision, or in the amendment, the provision had read that the Attorney General shall consult the Commissioner of Health. The language is instead now structured to say the Commissioner shall provide to the Attorney General upon request data and research, et cetera. That is the more traditional form of collaboration that our office has with agencies, recognizing our status as a constitutional officer with law enforcement discretion. Let's see. Moving on to the second page of the amendment, that exchange between transition to provided to is just kind of technical. And then there is the addition within the data practices language. It clarifies that the Attorney General Commissioner may make any data classified as confidential or protected, non-public, available to civil or criminal law enforcement. That is, so this, along with the other provisions that reference the Data Practices Act in the earlier version of the amendment, are all clarifying that kind of the AGO provisions of the Data Practices Act under provisions like 1337, those all we are trying to expressly carry over to this section to make clear that data is supposed to be treated as the AGO always treats data. This is investigative data until an investigation is concluded or until litigation is brought. And we ordinarily keep that as confidential, non-public, until there is a conclusion. It also ensures that that treatment is carried over at the Department of Health when they are working with us. Finally, there is just some clarification to the effective date of this prior version. Said that actions prior to enactment needed to be considered, and that was giving some folks some heartburn that only acts prior to the enactment would be considered. All acts relevant to the closing of a transaction are relevant to this consideration.
All right, thank you, Ms. Conti. Any questions from members of the committee regarding to the proposed A2 amendment? Not seeing any. Senator Umu Verbatim.
Thank you, Mr. Chair. I'll move the amendment.
Senator Umu Verbatim moves adoption of the A2 amendment to the A1 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Members, we now have before us the A1 amendment as amended. Is there any further discussion on the A1 amendment as amended? Senator Limmer.
I can draw your attention to line 11 on the A1 amendment, or page 11, lines 4 and 5. With the bill as it's written, gives the regulated entity its protections according to current law under Chapter 831, Subdivision 2. I don't know if that's in, if that reference is in.
Could you make the reference again, Senator Limmer?
Chapters, yeah, with the bill, the way it's written now, give the regulated entity the protections afforded by current law, chapter 831, subdivision 2.
831. Oh, 8.31, subdivision 2? Okay, I'm going to ask, please, members of the public that are in the room, please check your electronic devices and turn them to inaudible so they do not disturb the proceedings of the committee. Thank you very much.
Mr. Chair.
Ms. Conti.
And Senator Limmer, to the extent that we're relying on 831 to enforce the 831 protections would also exist, yes.
They would remain.
Yes.
Any other questions or discussion? Senator Kroon.
Thank you, Mr. Chair. Going back to page 10, lines 13 through 17, I know we had I had some questions about this from this morning, and my understanding now is that, and you can correct me if I'm wrong, with our conversation about that you think this is the information exchange between the Attorney General and the Commissioner is confidential data is a statutory requirement. Could you let me know what statute you're talking about?
Mr. Chair and Senator
Ms. Conti.
Ruin. So yes, what I was really poorly explaining in our earlier conversation before committee reconvened is that this entire blurb of language here is intended to carry over the Minnesota Data Practices Act provisions around the Attorney General and our civil investigations. So already civil investigations data is entirely non-public until we bring an action or until an investigation is concluded. So this language was intended to achieve that. It's a protection that is broader than work product, which is a phrase that I sloppily used this morning. There's also work product protections around a portion of this, but all pre-litigation or pre-conclusion of an investigation data is treated as non-public. So the addition of this language to this particular bill was just to clarify that treatment carries over to the sphere of authority. It was also to make clear that to the extent that we are relying on the Department of Health as a consulting expert in these cases, that we are sort of sweeping them under the treatment that we have of data for the time that their work is non-public because of the investigation, because of the potential for litigation.
Senator Kroon.
Thank you, Mr. Chair. Maybe I should ask Senate Counsel, is this investigative confidentiality requirement, is that the Minnesota statutes 13.39 statute? Okay. I
The
guess,
record should show, Ms. Primo nodded her head in the affirmative.
okay.
Senator Kroon.
Thank you, Mr. Chair. I appreciate that. I'm struggling with why 13.39 wouldn't be referenced here if that's what the intent is. And, I would also note that 13.39 speaks in terms of data, where line 10.14 here speaks in terms of information. Now, maybe those are synonymous, but it seems like we could use consistent terminology. And then I don't know exactly how 1339 works, but if you look down into subdivision 2A and subdivision 3, there's mechanisms to have people have access to that data under certain situations. And then there's a provision for when the investigation becomes inactive, none of which I would think would be incorporated into this without some sort of reference to 13.39. So I see what you're getting at, but I still think the language in the bill is kind of inadequate to really get at it.
Mr. Chair
Ms. Conti.
and Senator Kroon. So a couple of pieces. So information within the Data Practices Act is defined as data, and data is defined as information. So those two terms get bandied about, even though data is, I think data is the original defined term, but there's clarification further within the chapter that these are each of a piece. So we do reference portions of the Data Practices Act within that, I believe it's subdivision 7. There was a decision to the House version had all of the Data Practices Act provisions within that subdivision 7 for reasons of, I think, quirks of whoever configures things. In this particular version, the portion about our consultation ended up earlier in the draft, and then there's a second area talking about data privacy where it references 1302. I'm not sure why 1339 is not expressly also mentioned, but the goal was to echo that terminology, that investigative data terminology.
Ms. Primo.
Mr. Chair and members, I assume some of how this is structured is a result of piecemeal negotiation and drafting in both bodies over the course of maybe several committees or drafts. It might be best to, if the intent is to treat this information that's received from either a healthcare entity or the commissioner related to these transactions, I think it probably would be best to address the entirety of the data classification under subdivision 7, just leaving whatever is not related to the specific classification in paragraph E. And then instead of providing a classification to say the data collected pursuant to this section by a healthcare entity or commissioner is treated as provided under section 13.39, something like that. I'm sure there's a more eloquent way to say that. So if that's that's the advice I would have, if that's the intent, to treat it as civil investigative data, because there are a few things that seem a little bit different in terms of what happens to the data then when it's inactive data, and 13.39 provides that mechanism, as Senator Kroon pointed out.
Ms. Conti, what do you think about that suggestion?
Mr. Chair, I am delighted to be potentially returning to the happiness business here before this committee. I think that's a very reasonable change.
So Ms. Primo's going to work on the language specifically for that. She'll need a few minutes, so let's move on with the discussion. We'll return to that. Senator Kroon, anything else you wish to discuss?
Yes, Mr. Chair, on page 11, in the provision in section 3, 1114 through 1118, I'm just wondering whether charitable assets in line 11.17, whether that has any kind of definition that I missed, or whether it's in here or somewhere else in law. Because it's requiring under certain, if the nonprofit is sold to an out-of-state entity or a for-profit entity, they have to return to the general fund an amount equal to the value of any charitable assets the health maintenance organization or health system received from the state. It seems like charitable assets, I don't know if that's defined anywhere. What is that exactly?
Ms. Conti?
Mr. Chair and Senator Kroon, I will confess the AGO did not provide technical assistance on this particular paragraph. So at this point, we are relying on dusty memories from my brief time as a charities division person. But charitable assets does have sort of a common law understanding. I don't recall if it's expressly defined within 317A or not. But there's an extensive body of case law dealing with charitable assets, their valuation, and their disposal.
Senator Kroon?
Thank you, Mr. Chair. So there may not be a statutory definition, it may be common law? Is that?
Ms. Conti?
Senator Kroon, I can double check for you. Like I said, we did not provide technical assistance on this particular language, and I did not term check all of the pieces of this that we did not assist with.
Mr. Chair,
Senator Kroon?
if there is a statutory definition, I think this would be the appropriate place to put it. Now, maybe there isn't, and we just don't have that available, but if there is, it seems like it should be there, a reference to that.
We'll have counsel, when available, check on whether there's a statutory reference in 317.
Thank you, Mr. Chair. And then also on line 11.18, is there any time frame we're talking about here? It just says received from the state, like
11:18.
going back to the
Thank you.
organization of the history, the entire history of the organization, or what are we talking about there in terms of a timeline?
Ms. Conti?
And again, Mr. Chair, and again, with that caveat that we did not provide the technical assistance, charitable assets within Minnesota, so the Attorney General's office is the regulator in chief of charities, of charitable trusts, of those sorts of entities, and it is the office's job to make sure that charitable assets in Minnesota remain dedicated to their charitable purpose. There isn't sort of a time restriction on that. That is just always a duty of the office, expressly in statute, to make sure that assets aren't being diverted from their intended purpose or away from a charity.
Mr. Chair,
Senator Kroon?
if there's a specific statute that requires the Attorney General's office to track this, it seems like that would be an appropriate reference here as well. Another question could be, what's the data retention policy? Because some of these organizations could be decades old. I mean, are we going to have that information? Does the statute require it to be kept for a certain number of years? Do you know that?
Ms. Conti?
Mr. Chair, Senator Kroon, so yes, nonprofit entities do keep as part of their articles and founding documents, other records as well, representations about what their charitable purpose is and what their charitable assets are. So there are contemporaneous records even for entities that are hundreds of years old, like the Red Cross. And it is our job to make sure that they don't get diverted away from their charitable purpose.
Senator Kroon?
Thank you, Mr. Chair. I just point out if all these things are set forth in statute as part of the Attorney General's office, and maybe 62D, is that the reference, what's that reference to?
Mr. Chair and
Ms. Conti.
Senator Cruen, I believe 62D, I would need to double check, but your earlier question within that was, is this all written down in statute? These are duties that are spread out across a variety of statutes. So 317A, there are also provisions within 501B, within 309. And so the authority of the office is expressed, but it's also kind of littered throughout the statutes, and then in common law as well. So the Attorney General enjoys extraordinary common law authority to look out for charitable interests. So it would be challenging to kind of capture all of the sources of our authority concisely within this provision. We've attempted to do at least some of that by explaining that the powers that are here are supplemental to existing statutory and common law authority.
Any additional questions or comments, Senator Cruen? I will ask if Ms. Primo is prepared with regard to the Chapter 13.39 language. Ms. Primo?
Mr. Chair and members, yes, so turning to page 10 of the A1. Page 10, line 14, delete everything after the period. Delete lines 15 and 16. Line 17, delete everything before the first the. And then page 10, line 30, before the second data, insert section 13.39 applies to, after entity, insert and the commissioner. Line 31, after and insert data provided by a healthcare entity. Delete everything after section. Delete lines 32 and 33. Line 34, delete everything before the period. And I will read that whole sentence so that it's clear what it says. So it should read, section 13.39 applies to data provided by a healthcare entity and the commissioner to the Attorney General, and data provided by a healthcare entity to the commissioner under this section.
Senator Limmer inquires which lines after that are deleted.
Mr. Chair and Senator Limmer, the deleted lines would be 32, 33, and 34, except for the period that's on 34.
Senator Cruen, does that work for you?
Yes, Mr. Chair, I'll move the language as cited by council.
Senator Cruen moves adoption of the oral amendment as described by council. Does everyone understand the amendment? All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion on the A1 amendment as amended? Senator Howe.
Thank you, Mr. Chair. And, you know, I know each agency's got their own data retention policy, but is there some idea how long all this data gets kept? And
Ms. Conti.
Mr. Chair and Senator, I know that there are particular lengths depending on the status of an investigation. I apologize, I do not know those offhand. So there's a retention period of, I want to say it's 5 or 7 years for closed investigations, but I am guessing in this moment. The retention schedule, I believe, is spelled out in statute for us. Yes. But I don't know the exact parameters.
Senator Howell, no one seems to have the answer at their fingertips what the retention period is. I believe it's different for each particular type of data as well, so it's a rather complicated question. Can you take your answer offline? Thank you. Is there any further discussion on the A1 amendment as amended? Senator Carlson, would you like to move? Senator Carlson moves the A1 amendment as amended by the A2 amendment and other amendments be adopted. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. So, members, we now have the A1 amendment as no, actually, we've adopted the A1 amendment into House File 402. So now the appropriate motion would be to adopt the House File 402 as amended. I'll be recommended to pass and re-refer to the Committee on Finance. Before we do that, any further discussion? Senator Limmer.
Mr. Chairman, thank you. I'd like to ask the Attorney General's office a question. The way I understand it, the Attorney General has broad discretionary powers as it is. Over the course of this session, we've had specific bills specifying certain powers, certain authorities, which I always thought the Attorney General's office had anyway. So why are we making specific authorization when he has broad authority anyway?
Mr. Chair,
Ms. Conti.
Senator Limmer. So I can't speak to all of the efforts that have come forth this session, but at least with respect to this legislation, the concern is that while the Attorney General enjoys broad authority around particular entities like nonprofits, there are gaps because there are many participants in this field that aren't nonprofits or that otherwise are kind of exempted out of our notice parameters for overseeing nonprofits. And so there's a lot of transactions that we are not entitled to notice of upfront. So as we've seen, more than a decade of consolidation, rural hospital closures, these sorts of things, we have not had the tools we need to review, to try to take action where we see malign levels of consolidation. That is what we're attempting to remedy here. So a traditional charity, kind of with no special bells and whistles, we do have the ability to get information, to review books, to do those sorts of things, and to ultimately bring an action in court, asking the court to take extraordinary remedies, replacing the board, shutting down the charity, et cetera, to make sure that charitable interests remain for their purpose, for their charitable purpose to benefit Minnesotans. But there are a number of entities that we don't enjoy that sort of overview, that sort of breadth. So where we have power, we have broad power, but it is a mismatch in terms of the oversight that is needed, and that is why 29 states before us have taken this step of making healthcare transaction oversight more express.
Thank you.
Not seeing any further discussion. Senator Carlson, would you care to move the bill? Senator Carlson moves that House File 402 as amended be recommended to pass and be re-referred to the Senate Finance Committee. All those in favor say aye. Aye. Opposed? Motion prevails. All right. Thank you, Senator Wiklund.
Thank you. Thank you,
On your
Mr.
next
Chair.
stop. We are now going to take up
Thank you very much.
Senate File 2319, Senator Fateh.
think three is there a better order when those together? I don't know.
Would incorporate it all into like one thing together. Because it's not really amending, it's just adding more sections, so you could adopt that first and then
Adopt this first, A17.
the civil action. Yeah, I think so.
Because then it would be adopted to the A14.
Okay, members, we have Senate File 2319 in front of us. We have the A14, which was before us when we recessed earlier today. We have the A17 amendment, which is drafted to amend the A14 amendment, which has been distributed to members. So what we're going to do is take up the A17 amendment at this time. This is amendment which I believe has been drafted on behalf of the chief author. Is that correct, Senator Fateh?
Yes, Mr. Chair.
Senator Fateh, would you please describe the A17 amendment? And if you have any changes to it, I understand there might be one, tell us what those changes would be as well.
Thank you, Mr. Chair. There was two sections that were included that was previously missing. The first being some anti-discrimination language. It says a TNC may not discriminate against any of its drivers on the basis of disabilities, race, gender, and so on. The second piece is a civil action piece that I can have Mr. Cooper speak more to if you'd like as well. So those are just two pieces, civil action piece and an anti-discrimination piece.
Mr. Cooper,
Thank
to
you, Mr.
Section
Chair.
6 of the amendment.
Thank you, Mr. Chair. Looking at Section 6, I think there's one oral amendment, and that's on line 1.13. The words "three times" are stricken, so it would read now, "A prevailing plaintiff is entitled to the damages suffered," rather than "three times the damages suffered." Other than that, I don't think there's any oral amendments to that portion. I'm going to explain it now. That this particular is pretty straightforward enforcement mechanism for this statute. It follows pretty much the normal sorts of things. The things that are a little bit unusual slightly is the court may impose a $1,000 penalty. It does not have to, but it may impose it. It also allows the harmed party to bring this matter to court. It is, as I say, the sort of damages listed are pretty much what you normally have in a case of this nature. It has a statute of limitations of 3 years, and those are the highlight points, unless there's some questions. On the insurance issue, it says that the party has the right to either get the value of what the insurance would have cost, or if they lost out on insurance payments, the benefit that they would have received.
Mr. Cooper, where is the insurance language in the A17 amendment?
If we look at 1.14, this includes but is not limited to damages for failure to provide the required insurance, which shall be at least equal to the cost of the insurance, plus any benefits that were not obtained as a result of the insurance not being enforced.
Mr. Cooper, where did the $1,000 penalty level come from? What was your basis for that?
The $1,000 penalty level, I'm sorry, Mr. Chair, the $1,000 penalty level was based upon what appeared to be a reasonable amount if you had a case where the court felt that was appropriate under all the circumstances. You may have in some of these cases, that was a disincentive to have violations. You may have in some of these cases the perception on the part of the TNC that even if they don't follow the rules, they're not subject to much of a penalty, and this was to disincentivize that kind of thought process.
Mr.
But
Cooper,
it's in the discretion of the court.
is it your intent, Mr. Cooper, that the $1,000 penalty be separate from and/or in addition to damages suffered under paragraph B of the civil action section?
Separate in it, or addition to, I guess you could call it either separate or addition to, not subsumed by.
And Mr. Cooper, who then would issue the penalty?
That would be issued by the court if it felt it was appropriate. So the judge would issue that if and only if the judge felt it was appropriate.
And how would you define violation?
Violation, I suppose, is defined the way that anything in the court would be. The plaintiff, that is to say the driver, would have the burden of proving that this statute had not been complied with. If they failed to prove that the statute had not been complied with, they would lose. If they managed to prove that the statute had been complied with, they would prevail.
Would you consider each day that there is noncompliance to be a separate occurrence, or would it be a one-time occurrence that we're continuing?
I'm sorry, Mr. Chair, as I see it, there's no language to say it would be multiple violations. As I see it, the language does not envision such a conclusion.
And what was the basis for selecting 3 years as a statute of limitations?
The basis for selecting 3 years as a statute of limitations is the concern that some of these things can be completely hidden, and so the victim will not really realize it. Many of the drivers are not knowledgeable about the law. Many of the drivers are not conversant with these kinds of concepts. So that was the thinking of using a 3 rather than a 2-year statute of limitations.
Well, Mr. Cooper, the 3 years is from the date of discovery in your language here, so hidden or not really doesn't make any difference, does it?
Well, I guess you're right on that, except, well, yes, I guess you're right on that. I won't quibble with you.
So the question is either we use a discovery date with a determined number of years, or we delete the discovery reference and just be 3 years from the date of occurrence, which is more common. Mr. Cooper?
Mr. Chair, we would be okay with striking the one and leaving in the other.
Senator Fateh, you're the chief author of the bill. How would you prefer this? How would you like us to write this provision?
I'd be okay with the change, Mr. Chair.
Which change? We were just told by Mr. Cooper, one or the other.
Yeah, you can either go.
That gives us no
from
guidance.
discovery. I would go 2 years from discovery.
Yeah, 2 years from discovery. From 2 years of discovery, Mr. Chair.
2 years from discovery is your desire?
Yes, Mr. Chair.
So those are the questions that I have for the moment. At the appropriate time, we'll ask if there's any member of the committee wishes to offer the A17 amendment, and any changes that were made orally, we'll ask to have incorporated into the amendment so that we don't have an amendment to the third degree, which is not parliamentarily acceptable. So let's see if we have any further discussion or questions regarding the proposed A17 amendment. Actually, I do have one other question, if I may. There's this anti-discrimination provision. Seems to me it would only be necessary if Chapter 363.8 is not applied to this kind of an entity. So I'll ask counsel, does the Minnesota Human Rights Act apply to a TNC already?
That is debatable.
Mr.
Oh, I'm
Cooper,
sorry.
I'm asking Senate counsel.
I'm sorry, I
Thank
apologize.
you.
Mr. Chair and members, so a TNC is not, a TNC driver is not considered an employee, they're an independent contractor, and there are certain instances under which 3638 may apply, but generally, those protections don't apply absent some specific things under case law as well.
Okay, in which case it would be beneficial to have this separate non-discrimination provision, just to make sure that they're covered.
Yes.
Okay, I understand. Thank you. Any questions or comments from members of the committee? Senator Seeberger.
Thank you, Mr. Chair. As it relates to the non-discrimination provision, I'm wondering if, in looking at line 1.5, and it talks about not discriminating against any of its drivers or applicants to become drivers, and as I understand it, municipalities in which these TNCs operate all have qualifications for their drivers. And so my suggestion for this language would be to add the word qualified before the word applicant, such that, if you're not even qualified to become a driver, even applied to be a driver under that municipality's qualifications, this doesn't open the door to those folks that wouldn't be qualified for the position anyway.
Senator Fateh, what is your position on Senator Seeberger's proposal?
I think that would be an okay change with me. Thank you, Mr. Chair. Thank you, Senator Seeberger. I'll be okay with that change. Thank you.
Okay.
Senator Kroon.
Thank you, Mr. Chair, I don't have any questions about it. Is there?
I thought I
is that
saw
an
your
amendment?
hand go up.
No, I do on the A17 in general, but I don't know if, was that an amendment?
Any further, well, we don't formally have the amendment offered, so.
I can ask
this'll-
my questions though.
Senator Seeberger, did you have anything further with regard to that topic that you just raised? Or anything else on the A17 amendment?
Nothing with regard to that topic, but I do have a problem with lines 1.18, 1.19, where, back to me arguing the American rule. I don't see a compelling reason here why a prevailing plaintiff should be entitled to reasonable attorney's fees, costs, and expenses. That's not a provision that I can agree with. I guess that's, at a micro level, I would like to see that language stricken, but I'm wondering why, whether we need this Section 6 provision for a civil action at all, and if we do, I'm sort of all over the map here, but it just seems to be a lot of words here. Why can't we just leave it at, end it after 1.12? I guess, why do we need paragraph B at all, or C? I'm sorry, Mr. Chair, I'm all over the map. I'm sort of verbally thinking out loud here, but I'm not sold on the need for Section 6 at all. I guess I'll start there.
Senator Fateh.
I'll defer to Mr. Cooper if that's okay, Mr. Chair.
Mr. Cooper.
Mr. Chairman, Senator, you've raised a number of issues. I'll try to go through them one at a time. First, you raised the issue of attorney's fees. If you think of whistleblower, if you think of the Minnesota Human Rights Act, acts that often have a huge disparity in power, where you have an employee who is making very little against a national major corporation for these kinds of violations of statutes. That's what the whistleblower does, and that's what the Minnesota Human Rights Act does. The reason for that is to make an opportunity for harmed people to actually get an attorney. What the testimony you've heard at some of the other levels of the conversation was that drivers were never able to get an attorney, and because of the fact that attorneys wouldn't take these kinds of cases. Adding the possibility of reasonable attorney's fees allows equalization of that. That was your first question. Mr. Chair, can I go on to the other question?
Mr. Cooper.
Thank you. The next question you had, I think, was why do we have the other sections at all? typically you want a court to know what are the damages that are appropriate for this particular violation. If you leave a word hanging out there that just says damages with no clarification or definition, it can lead to very inconsistent interpretations as various different courts attempt to apply this statute. That's the reason for the additional language. I think I already explained the last part, the $1,000 part. I'm not sure I answered all your questions. If I didn't, then please remind me of what I didn't answer.
Senator Seeberger.
Thank you, Mr. Chair. And I appreciate the input. I guess my first inclination would be to, I don't even know that we need a civil action here, but to the extent that we do, and we think it's necessary to spell out elements of damages, at the very least, I can't agree to language that calls for a prevailing plaintiff to be entitled to reasonable, unless we change the word plaintiff to party, a prevailing party is entitled to reasonable attorney's fees, costs, and expenses. I would agree to that change, but my preference would be to take that out, simply function under the American rule. I don't agree that this rises to the level of a whistleblower type action or consumer protection type action or civil rights type action. We're talking about legislating insurance coverage and compensation, and this should be something that parties are compelled to bear their own costs for. To the extent that a plaintiff prevails, they're already getting their damages, and the cost of an attorney to get that is the cost of bringing a lawsuit. Thank you, Mr. Chair.
If that was a question, I'm happy to answer,
It
Chair.
does
I'm
not appear
sure.
to be a question, Mr. Cooper.
I'm sorry.
It appears to be a statement, not a
Okay.
question, Mr. Cooper. Senator Seeberger, this is an ongoing kind of philosophical discussion we've had on other bills as well. And so as a practical matter, it's highly unlikely that an individual driver would have the resources to be able to bring any kind of a claim, unless they were in conciliation court, perhaps. But so, in that sense, a fee shifting provision is a key to the courthouse in the same way a contingent fee is in a personal injury case. And if plaintiff were changed to party, then no one would ever bring a claim, because you'd have a major corporation having attorney's fees, which would be far in excess of the ability of any potential claimant here to be able to pay should they lose. So they would never take that risk. It just, potential for damages would be completely overwhelmed by their potential exposure for attorney's fees alone. So I guess if we have a civil action provision, I'd be inclined to leave that provision, that piece of it in there. But I do have a question, because there are, with regard to civil actions and damages descriptions, there are a lot of regulations within this proposal, some of which, it seems to me, are the kind of the ordinary business dispute kind of regulations, and some of which would be the kind that would be more common to result in emotional distress damages. In an ordinary business dispute or a contract dispute, you don't get emotional distress damages. You get simply the financial cost of the contract violation. Here, there's a wider range. There's a discrimination provision, but there are also other more typical contract kind of provisions in here. So I'm a little concerned about having such a broad description of damages for what might simply be contract-type violations. Mr. Cooper, Senator Fateh, what are your thoughts on that?
If I may answer, Chair, you are correct. There are some parts that are primarily contract, but the vast majority of this is not. For instance, if you've been in a serious automobile accident, and, excuse me, I didn't mean accident, if the insurance provisions are not covered and you are in fact not compensated, the emotional distress from that would be significant. If in fact there's a pattern in practice of dismissing people for discriminatory reasons or dismissing people because they will not go along with what the company wanted in terms of what legislation should be. During this legislative session, we have, I guess I said 700 members this morning. We have more like 1,200 members. Quite a number of them have already been dismissed through without an explanation. Now, whether it's because they participated in this process or not is a question mark, but we still have the fact that that causes significant emotional distress. I understand what you're saying, and on the parts that are in fact purely contract, you're right. But in the other parts, I don't think so. So maybe we could add the words where appropriate. The courts are very well versed in where emotional distress is and is not appropriate.
Mr. Cooper, let me just clarify this, because you've just leveled what could be a pretty serious accusation. Do you have any evidence whatsoever that any particular driver has been dismissed because of their participation in this legislative process?
Anecdotal. I'm not saying that is something I have proof of, and that's, it may or may not be, but I do have.
Is that anecdotal evidence specific factual allegation, or is it speculative on the part of a particular driver?
It's the statements of particular drivers
right,
as
so-
to the fact that they were, there was no reason to terminate them, and then suddenly they were terminated. Now, I thought
Do
I
you have any
cushioned.
reason to believe that Uber or Lyft has knowledge of whether any particular driver is attending a hearing today or has been participating in this legislative process?
Yes, I do. One of the things that we've mentioned, and I don't want to go too far down this road because it's a
Well,
distraction.
you brought it up, Mr.
I know. I'm going to answer your question, but I don't want to go too far down the road. What we had in this case, in this legislation, as you may know, Uber induced a small number of drivers to create a new organization. And then they claimed they had settled the disputes here at that small organization. They sent an email out to many of the elected officials to as much. Then later retracted that email and said, no, that's not quite correct.
All right.
But
I'm sorry, I'm going to interrupt you at this point.
Yeah,
We're
I
not
didn't
going to
wanna
go
go
down this road.
Fair enough.
My understanding is that the organization of drivers that Uber has been working with existed prior to any proposals relating to this legislation. But we're not going to go into a factual dispute over the history on that. So
Fair
let's
enough.
just, please, Mr. Cooper, be very, very cautious about what accusations you make in this public setting that could have an impact legally, perhaps, relating to any other participant in these legislative proceedings.
Fair enough, but I think I was. I thought I put the caveats on there, but I understand what you're saying.
All right, is there any other questions or discussion from members of the committee with regard to the proposed A17 amendment? Senator Limmer.
Thank you, Mr. Chairman. We've kind of taken a broad sweep of a variety of different suggestions on this A17. I would like to, we started with a discussion on statute of limitations. And I would like to hear a reaction from, Mr. Chairman.
I'm sorry, go ahead, Senator
That's all
Limmer.
right. We started with a discussion on statute of limitations.
Yes, sir.
And we've heard direction from the author, but I was wondering if I could hear a reaction from representative of the opposition to this bill regarding the date of discovery statute of limitations. Mr. Joel Carlson is in the room. And
Senator Limmer requests Mr. Carlson's testimony regarding the statute of limitations proposal on behalf of his client Uber. And the other Mr. Carlson is present and wishes to testify to that if there's anything additional, that would be fine as well. Mr. Joel Carlson, go ahead.
Thank you, Mr. Chairman and members. Joel Carlson here on behalf of Uber Technologies. I would like to have a chance to be heard on the A17 generally, but just to the question of the statute of limitations. Minnesota does not generally recognize the discovery rule. So having that discovery rule in here, particularly without any statute of repose, is particularly problematic. And so I would like us not to go down the discovery path, particularly without any end date. And as far as an appropriate number of years, I think that we have a current statute relative to contract cases right now, which is what these are. And so I don't think we need a specific statute of limitations in this particular provision at all. And for sure would not want a discovery rule without any statute of repose.
Senator Limmer.
Mr. Chair, well, Mr. Carlson is there. Mr. Carlson, I know you were in the room listening to the other suggestions on the A17. What is your client's reaction to the A17 amendment as it is, and including some of the suggestions that were discussed?
Mr. Carlson.
Mr. Chairman, if you're ready for comments on the A17, I'm happy to.
To the A17.
Thank you. Senator Limmer, I would kind of like to talk about them in two separate divisions. I'm not, it's your job to divide the amendment, not mine, but as it relates to discrimination being prohibited, we certainly don't have objections to that. We don't do it. We have just anti-discrimination policies. We do have a problem with applicants who may not be qualified, and I appreciate Senator Seeberger picking up on that point. You have to understand that the state doesn't regulate these businesses. They're regulated at every local level. And so we have a statute that provides anti-discrimination but doesn't know the terms of which you're providing that on. So qualifying that language is very helpful as it relates to the first half of the amendment. I have serious reservations about Section 6 of this amendment. And I've been before you dozens of times when consumers and others have a need to remedy themselves in the court because they've been aggrieved in a way that is fraudulent or damaging. And I've supported those and continue to support those. I've also been here, even this session, and opposed attorney fee shifts and civil remedies because they weren't appropriate and needed. I think of Senator Seeberger's bill about the oil refinery where the civil action was removed, or Senator Klein's bill regarding genetic testing where I testified against adding a civil cause of action. I don't think it's needed here. And this language, which I don't think is really very well written, has a huge problem. And Mr. Cooper put an exclamation point on it. He said, if you're not paid your insurance claim, that causes emotional distress. Many times, the company itself will have an insurance carrier that will settle an insurance claim, and they may determine that the accident didn't arise from your work or your driving experience, and they may deny that claim. Under this provision right now, they would have a chance to bring a claim against the TNC for that denial of an insurance benefit, which the company didn't even necessarily control. It makes either the insurance that's in this bill mandatory that you have to pay every claim, or you subject yourself to subdivision 6. I don't think that that is written properly, and I agree. I think they have a civil cause of action right now. I don't think we need subdivision 6. I certainly prefer lines 1.18 to 1.19 being removed, but I think if you need to have something in there, just stopping at 1.11 and 1.12 is more than sufficient.
Thank you.
Mr. Cooper.
Well, I'd like to point out that the language in here does not allow Mr. Chairman, it does not allow that scenario. It says, for failure to provide the required insurance. That means not to buy the insurance. There's nothing in here that cast onto the TNC the story that was shared by Mr. Carlson. The reality here is this is merely the enforcement mechanism of this statute. It just merely makes clear that the district court does have the opportunity to look at these cases should they be brought to them. I don't see where the analysis that was made by Mr. Carlson is applicable to the language that is in this statute.
Any further discussion on the proposed A17 amendment? Senator Cruin.
Thank you, Mr. Chair. I'm getting caught up on the statute of limitations as well. I don't know why just the standard statute of limitations for contracts in this state wouldn't be sufficient, and why we even need a statute of limitations provision, a special statute of limitations provision in this bill. And maybe the question is, can you give me some examples of where a driver wouldn't know that they had a claim or a civil action under this for more period of time than the standard statute of limitations for contracts? Just help me understand what we're talking about here and why it's needed.
Mr. Cooper.
Thank you, Chairman. Senator, it could come up in a number of places. Don't forget that a lot of these drivers are not conversant in the law, and some of them are not super conversant in English to begin with. We have a situation where what happens and you might have remembered this morning, Mr. Carlson was concerned about giving them information about, giving them information about their own situation. He was objecting to saying somehow that it was a trade secret, to letting them know how they were being paid and why they were being paid. That, of course, is one of the things we're asking for here. But if you're not being given the information of how you're being paid or why you're being paid, you may not discover the fact that you're not being paid at the rate you should be being paid. That's an example. But I don't want to bog down this conversation on the statute of limitations issue. If people are more comfortable saying a 2-year statute of limitations, which is the standard contract statute of limitations, I don't think we want to waste a lot of time on that because there's other things to get to. So if that would make people happier, we'll withdraw the proposal of 3 and make it 2.
Mr. Cooper, are you proposing but you still leaving discovery in the language, which without a statute of repose? So.
No, I'm sorry, Chair, I'm proposing the opposite. I'm proposing the statute of limitations just merely say 2 years. And that would be in line with the norm.
Is that current law? What is current law on contract statute of limitations?
I don't know this is a contract case, and that's the problem here. You know, it could be considered negligence. It could be considered a variety of other things. Negligence, as you know, is 6 years. What this would be interpreted as, it seems to me it's better to have the statute clear as to what the statute of limitation is rather than ambiguous. But in any event, that's my suggestion.
So your suggestion is, Mr. Cooper, is to change 3 to 2 and delete the discovery component?
That is my suggestion.
So as we're following along here, members, the point we get at which an amendment may be offered, Mr. Cooper is suggesting on line 1.22 that the word 3 be deleted, and in its place, the number 2 be inserted, and line 1.23, delete discovery of. Okay, council has a better suggestion for drafting this provision. Ms. Primo.
Mr. Chair and members, delete lines 1.2 and 1.23 and insert a new paragraph D. An action brought under this section shall be commenced within 2 years. This is just typically how it's drafted in statute.
Mr. Cooper, are you okay with that drafting? Senator Fateh?
Yes, Mr. Chair.
All right, so we'll hold that language for insertion in any proposed A17 amendment. Is there any other? Why don't we formally have the A17 amendment placed before us so we can do further work on it, if anything? Senator Wiklund moves the A17 amendment. Is there any discussion among the committee with relation to the prevailing plaintiff language? I'm just going to try to identify the points that have been the topic of discussion, and we can decide if we want to proceed on any of those individual provisions, and then we'll consider the amendment as a whole.
Actually, Mr. Chair,
Senator Seeberger.
I would, okay, we have the A17 amendment before us. I guess I would move to amend it by deleting lines 1.13 through 1.21.
So members, just so we're procedurally clear here, what we're going to do, because we're running into a parliamentary question about amendments to amendments to amendments, is we're going to consider the A17 as an amendment to the bill, and if it's adopted, then we'll include an instruction to council to correct the page and line numbers so it's treated as an amendment to the bill and not as an amendment to the A14 amendment. So we now have before us Senator Wiklund's motion to amend the A17, to adopt the A17 and amend the bill with the A17. Now we can proceed to have discussions within the A17 amendment if there are going to be any changes. Senator Seeberger has moved to delete lines 1.11 to 1.21. Did I get that right? 1.13. 1.13 to 1.21. So it would leave in the paragraph establishing a civil action, but delete the definition of damages and plaintiff's fees and the civil penalty provision. Is there any discussion with regard to Senator Seeberger's motion? Not seeing any. Senator Seeberger moves to amend the A17 as described. All those in favor say aye. Aye. Opposed? The motion prevails. The amendment is adopted. So we now have before us the A17 as amended. Do we have a motion to amend the statute of limitations language formally to change on line 1.22 the number 3 to the number 2? And I'm sorry, the language as Ms. Primo described it.
So moved.
Senator Seeberger moves the language Ms. Primo described as to the statute of limitations and to delete lines 1.22 and 1.23 in this place. Senator Limmer.
Mr. Chairman, could I hear from Mr. Joel Carlson on his reaction to this amendment.
To the statute of limitations provision in particular. Mr. Carlson, Ms. Primo's language, if there were to be a statute of limitations provision, would you prefer that language or some different language?
Mr. Chairman, we'd support that language.
All right. Thank you.
All right. Members, to Senator Seeberger's motion to adopt the language on statute of limitations as described by Ms. Primo. All those in favor say aye. Aye. Opposed? Motion prevails. That amendment is adopted. So we now have before us the A17 as amended. It includes the statute of limitations language. It includes the civil cause of action language on lines 11 and 12, and it includes the discrimination provisions. I think if we wish to consider Senator Seeberger's suggestion to insert qualified before the word applicants, we should do that formally as well. On line 1.5, before the word applicants, insert qualified. Is that your motion, Senator Seeberger?
That is my motion, Mr. Chair.
Any further discussion on that motion? Seeing none, all those in favor say aye. Aye. Opposed? Motion prevails. That amendment is adopted. Is there any further discussion on the A17 amendment? Not seeing any. We are now on Senator Westland's motion to amend the underlying bill with the A17 amendment as amended. All those in favor say aye. Aye. Opposed? The motion prevails. That amendment is adopted. Members, we are now going to consider the A14 amendment. I think we need to make one correction since it's a delete everything amendment, that now it would be a delete everything except the A17 amendment that was just added to the Senate File 2319. Is that correct, Ms. Primo?
Yes. Just give me
All right, Ms. Primo can be directed as a part of any motion to make those adjustments linguistically in the nature of revisers' corrections. So now, to the A14 amendment with that adjustment. Is there any further discussion? Senator Seeberger.
Thank you, Mr. Chair. It's my understanding from our conversations earlier today in committee that notwithstanding the fact that there's some insurance provisions in here that arguably are subject to commerce and not necessarily our committee, that kind of fair game to discuss these provisions. Am I on the right track here?
Senator Seeberger, we've been asked to consider a delete everything provision, and since we're the last committee in the row here, I think everything in the bill is going to be considered game for consideration by this committee today. And we'll just have to take it
Thank you,
from
Mr.
there.
Chair.
Senator Seeberger.
My comments are with respect to Section 2, which begins on page 1 at line 1.20. And it has to do with insurance requirements. And between hearing the bill earlier today and the current time, I've had an opportunity to speak to Mr. Cooper, Mr. Carlson, Aaron Cocking at the Insurance Federation to try to make some sense of this particular provision. And my concern lied with, on page 2, lines 2.8, 2.9, well, and up, starting at 2.3, sort of what this insurance was. Was this $1 million in med pay on an auto policy, which there isn't such a thing? Or what exactly was this insurance? And in speaking with Mr. Cooper and Aaron Cocking and Mr. Carlson, I think I've got a handle on what the bill is trying to get at here, but I have to say it's rather inartfully drafted and difficult to understand. If we begin on and following my conversations with Mr. Cooper, if we look to line 1.24, Mr. Cooper, am I correct that you will agree to strike the words already and fully in that sentence to make it more clear as to what we're talking about here when it comes to the two different coverages?
Mr. Chairman
Cooper.
and Senator, yes.
Mr. Cooper, just for protocols here, just so the record and the recordings are clear, if you would please just wait until I recognize you before you respond directly to a question. That way, the recorded record will reflect who is speaking before the speech begins. It'll be easier just to keep track if someone is listening to this somewhere down the road doing research for a law review article somewhere.
God help
Which
'em.
this might turn into one of those case examples. So, Mr. Cooper, what was your response to Senator Seeberger's question?
Mr. Chairman and Senator, yes, on line 124, the words already fully, we agree to have those two words stricken.
Okay. Senator Seeberger.
In that case, Mr. Chair, I would move that the words already and fully on lines 1.24 be stricken.
Any further discussion on Senator Seeberger's motion? All those in favor say aye.
Aye.
Opposed? Motion prevails. That amendment is adopted. Senator Seeberger.
Thank you, Mr. Chair. So this helps to clarify that we're really talking about two different insurance policies. One, which is the policy that's set forth in 65B.472, which is an auto policy relating to TNCs. And the other is a policy that would provide coverage over and above that auto policy, and as I understand it, would specifically get at instances where a driver is not within occupying, maintaining, or using a vehicle, which would get you within the realm of an auto policy and coverage there. And the scenario, as I understand it, would be a driver, let's say, who is maybe between, I don't know, you call them, between riders, still logged in, ready to take a fare, a rider, steps out for some reason and is attacked and sustains injuries that way. And so the idea, as I understand it, is to have some sort of medical coverage or coverage for that driver who finds himself or herself in that situation. And so that's where we come to the insurance provisions here that we see on lines 2.3 through 2.11. And in having these conversations with Mr. Carlson and Mr. Cooper and Aaron Cockring, I think that we still have some work to do here, especially when it comes to 2.8, 2.9, 2.10. And I guess I would ask Mr. Cooper this question. There was some proposed language that would incorporate occupational accident insurance into these provisions instead of a blanket $1 million for medical, $500,000 for disability. And I guess my question is, and my understanding is that that was acceptable at one time. Would that be acceptable to introduce this language because that's a product that already exists, that can already be purchased, rather than sort of nebulous limits for a product that I don't think is out there?
Mr. Cooper.
Thank you, Chairman and Senator. No, that would totally not be acceptable. And I thought I explained it to you, but let me briefly go into it now. If you look at 65B.472, for an automobile accident, the possible benefits are much greater, and they are $1.5 million and $1 million. What we're talking about here, and by the way, in other committees, we've had many, many people testify who these things actually happened to this year. And what we're talking about is somebody who pulls in behind the apartment building where they've been asked to pull in by the passenger. The passenger gets out, calls them out of the cab, shoots them, stabs them, beats them. The number of those incidents we've had just this year are significant, and those people have testified. One woman testified about how her husband, she had 5 children, was pregnant, was shot to death. She got absolutely no benefits from Uber, no benefits from anybody. She now has to raise those 6 children with absolutely no compensation. When we're talking about the people that are shot, we've had testimony from people who had to be in the hospital for 3 to 4 months. And when they came out, they were unemployable. They got absolutely nothing. And so we have a situation where the medical bills get cast upon the taxpayers and nothing else goes to these people. We have folks who are permanently unable to work for the rest of their lives. Now, the occupational therapy, I don't mean therapy, I misspoke, I'm sorry. The occupational insurance that Uber has been suggesting would give only up to $250,000 for medical damages and then virtually nothing else. You'd get 2/3 of your salary for 3 years. Say you're a 21-year-old driver. You're going to college, you're skilled, you're capable, you've got a bright future. You get shot, you get knifed, and you have brain damage. As a result of that, your whole life as an employee is over. To say that we'll give you, say you're one who's making $200 a week. The most, because you're part-time, the most you're going to collect is $200 a week, 2/3 of that, times 3 years. What is that, $10,000? You're going to get virtually nothing. However, if that exact same driver got blindsided by a truck and got injured and had brain damage, they would have the 1.5 million and the 1 million. This is lower. This is 1,500,000 that comes to you under 65B 472 or 442. I'm sorry, I may have misstated the number. But in any event, 472. The difference here is massive. If you have the insurance that Uber's been suggesting, you never get to the limits. You never get even near them. You'd have to be making $500,000 a year to even get near those limits, and a Uber driver does not make that. What we're looking for here is to cure a very real, and some of you have been in the other committees, a very compelling situation where people are being either killed or seriously injured. And these cases right now, they get $0, and they don't get their medical paid. And so what has to happen in those cases, I'm repeating myself slightly, is the taxpayers pick up the medical, and as far as the rest is concerned, nobody picks it up. And usually they get terminated if they try to come back. They don't have their job at Uber anymore. So no, that other suggestion that Uber has floated is not acceptable. Well, let me go to the term occupational insurance. There's nothing wrong with the term occupational insurance. We could, right now, workers' comp would pick this up under Section F if that's what the other side wanted. And we had proposed that and it was shot down. And what am I talking about? Our workers' compensation will allow an independent contractor, the employer of an independent contractor to put them on a workers' comp policy. That was our first suggestion. It hit backwinds, and a lot of the things you may have noticed in our bill, we've taken lots of things out in an effort to accommodate other people's points of view. But this is not something that can be accommodated. This is one of the most important parts of this bill. This is the part that doesn't ruin people's lives because of and don't forget, when you're talking a Uber driver, you're talking, in some people's mind, a moving opportunity to steal. You can bring them wherever you want them, and then when you get them there, they're all by themselves. But you're not. We had one a couple of weeks ago where
Mr. Cooper,
Mr. Chair.
I'll stop. I don't really want
I'll
to
stop.
go on for half an hour on this insurance question.
Fair enough.
I think the more direct question is, if there isn't an insurance product available to provide the coverage that you are proposing to be covered, what is Uber supposed to do?
I don't accept their claim that there isn't an insurance product available. First, they told us that you could not get workers' comp, and you can. It's right in the labor and industry words. It's right in the statute. It's there. As far as this, I called, and I don't believe them that you can't get this policy. But one of the things that we had suggested earlier is we can put a delay on it and say that the policies don't have to be purchased for 6 months. The other thing is, you mentioned Alan Cocking. Alan said that almost always when there is Aaron, I misspoke. Almost always when there is a demand for a product, the insurance company will provide it. We don't have any
Mr.
reason
Chair.
to believe that won't happen right now. Now, let me point out one other thing. One of the pieces of testimony of the Uber individual who testified here earlier today was there's no occupational one available either. His testimony was the kind he was suggesting isn't available either, except in very limited numbers. So this is an acute, immediate need. Every time I've checked, the things are available, but even if they aren't, the cure is merely to put a delay on it.
Senator Seeberger.
Thank you, Mr. Chair. And I'd like to clarify that Aaron Cocking represents the Insurance Federation, not Uber, not Lyft.
No, I'm
He
sorry.
has information with regard to what insurance products are out there in the state of Minnesota and available, what are approved by the Department of Commerce, and what can be readily purchased and available. I spoke to Mr. Cocking while the prior bill was being heard, so just about 45 minutes ago. And I asked him this very question. And he assured me that there is a product available within the state of Minnesota that would be workable, that was already in existence, and in his view was a feasible alternative. So that wasn't coming from Uber or Lyft. He also told me that while he did tell you that, yes, insurance products evolve given the need that's out there, it's not an immediate process. It's not a 6-month process. It's not a 12-month process. And there's no guarantee that just because we write legislation calling for an insurance product that doesn't exist, that something will all of a sudden come on the market. If there is a need, the insurance industry generally fills that need, but it takes years. And that's what he told me not 45 minutes ago.
Senator Seeberger, do you have a suggestion for how to fix this today?
I do. I have a suggestion to substitute the language calling for the $1 million in medical cost and $500,000 for disability with occupational accident insurance language. And I have that here. Just trying to figure out where we would put this. Maybe if I could pass for just a minute while I figure out where this would go and then come back and offer an amendment.
Yeah, Ms. Primo will come over to help identify where this might go, and I will ask, as you're doing that, if that kind of insurance could provide limits, has some flexibility in the limits. While we're doing that, I'm not sure, I don't want Senator Seeberger to miss any further testimony on the insurance question. At one point, we will give Mr. Carlson the opportunity to address the committee with regard to the insurance provisions. Independent of the insurance provisions, then, is there any other discussion on the A14 amendment? Any questions or concerns that any members wish to raise? Senator Kroon. Senator Howe. Okay, you guys decide who's going to raise your hand.
All right.
And
Thank-
actually, you know what, maybe I'm going to do, because I don't want Senator Seeberger to not be able to participate in this discussion. Why don't we take a pause here until Senator Seeberger is ready? So we'll give it a few minutes. We will temporarily be in recess, but I would not leave the room, because when we're ready, we're going to gavel right back in. So, all right, we are in recess. Committee is called back to order. The committee is in recess. That's fine. Committee is back in order. We have an announcement to make. The number of nuclear tipped multiple independently targeted reentry vehicles with a cap of 2,000%. Peace will prevail between Russia and the United States. Again, another reference that is not understood by the younger generation. Senator Seaver.
Thank you, Mr. Chair. I would like to offer at this time the A18 amendment.
Members, you have all been provided with a copy of the A18 amendment. Senator Seaberger.
Thank you, Mr. Chair. This is the product of the negotiations that occurred while we were in recess. And legal counsel is prepared to, there's a few oral amendments, and I'm going to, do you want me to handle that, or you want to take a shot? I'll hand it over to Priyanka. Ms. Primo.
Mr. Chair and members,
Ms. Primo.
there is a technical, some technical things I need to take care of because as you'll note, this is an amendment to the A14 amendment, and I understand that we're going to be amending the A18, so I would just like the same direction that the committee provided earlier to make this an amendment to the underlying bill, and that the A14 is not a delete everything. It just deletes everything except what will be adopted in the A17 and the A18, and to make the appropriate corrections related to that.
You have that direction. Senator Seaberger.
Thank you, Mr. Chair. So in terms of the A18, we will be deleting lines 1.13 through 1.16. So I would move that that language be deleted.
Why don't we, Senator Seaberger, if you could give us the framework for
Talk
this?
about
And
it.
so then we will have context for deciding whether to agree with your request. Or actually, you're going to be the author of the amendment. I guess you can offer it any way you want to.
Sure.
So let's do it that way. Why don't you tell us what you want in or out, and then we will take it from there. So you want those lines deleted? You're the author of the amendment? Then
Yes.
you will be offering an amendment without those lines. What other changes would you like to make to your amendment before we consider it?
Correct. And the other language to be deleted starts at line 1.30, after the period, beginning with weekly, and all the remainder of that language. And on 1.31, all the language up to the word "and," including the semicolon. And those are the changes to the A18 amendment.
Senator Seaberger, on line 1.30, delete the period, and on line 1.31, keep the semicolon?
Correct. Yes, thank you.
Okay. Any other changes to the A18 amendment that you'd like us to incorporate?
Those are all the changes.
Okay, Ms. Primo also has some changes to suggest to the author of the amendment. Ms. Primo.
Mr. Chair and members, so this amendment is intended to replace Section 2 of the A14. So I would suggest that we delete line 2.19 of the A18, and instead, as a separate motion or amendment, Senator Seeberger deletes Section 2 of the A14, and that's because now the A18 is not to the A14, it's to the underlying bill, so we're going to take that together.
Ms. Primo, can Senator Seeberger include the deletion of Section 2 of the A14 in the A18 amendment? Or does she have to make a separate motion for that?
Mr. Chair, she can incorporate that into the motion. It's just that on line 2.19, those are page and lines to the amendment, so I just don't want that piece included. It's
Okay,
to the
so-
A14.
So on line 2.19, replace the language with words to the effect of delete Section 2 of the A14 amendment. Senator Seeberger, would you like to incorporate that into your A18 amendment?
Yes, I would ask that that be incorporated, please.
Now, Senator Seeberger, to the A18 amendment as you would like us to consider it, would you please describe it for us?
Thank you, Mr. Chair. The A18 amendment sets forth a little bit better description of insurance that will be available in the scenarios that we discussed, and it would be occupational accident insurance with a minimum aggregate limit of $1 million and at least medical expenses of $250,000, and then sets forth how continuous weekly compensation of total disability payments would be made. The changes that I made, the oral amendments that I made, would be to delete a requirement that companies file with the commissioner a copy of the policy to avoid triggering some kind of a fiscal note, and the language with respect to disability payments, capping it at 156 weeks, is also deleted. And this would also provide for accidental death insurance to spouse and dependent children, and provides that benefits received would be treated as if it was work comp, so the recipient would not be taxed. That is my amendment.
Senator Fateh, what is your position on this amendment?
May I defer to Mr. Cooper before I speak, Mr. Chair?
Mr. Cooper.
Thank you, Mr. Chair. There's a couple of words in here that I don't know if they're intended or not, but it uses the word accidental a number of times, and these are often intentional acts where somebody intentionally robs you, intentionally shoots you, so I think the word accidental is inappropriate. It also, and it's in several places, it also, for the benefit to the spouse and family, still has the 156-week language in there, and I don't know if that was intended. I think that might have been accidental. So I'd ask the author, was that intended, or was that just an oversight?
Can you point out where in the amendment you're referring to, Mr. Cooper?
Yes, I will, Mr. Chair. If we look at the backside of the paper, line 2728, I mean 2.7, 2.8, shall be equal to the Transportation Network Company's driver's average weekly wage for 156 weeks. And then also
So let's address that first, if we may.
Okay.
Is there another place where the 156-week language is that you're concerned about? Yeah, that was deleted, right? Mr. Cooper?
Oh, I'm sorry. Could you say that again, Your Honor? I mean, Mr. Chair.
Is there any other place in the A18 amendment that contains the language you are concerned about 156 weeks?
I believe the other references were deleted.
All right. Senator Seeberger, what are your thoughts on that 156-week language on line 2.8?
Thank you, Mr. Chair. This was not a part of the negotiation that we discussed. We discussed the aggregate limit of $1 million. We discussed medical expenses. We discussed disability payments. We had no conversations with regard to accidental death. And in fact, that was not even a part of the original language in the amendment. So it was not something we talked about, not something we agreed to, and I'm prepared to offer my amendment as it is.
Mr. Chair.
Just a friendly reminder, please silence your audio or your electronic devices while you're in the committee room. Of course, as soon as I say that, mine's going to light up or something like that. But that was yours. Okay.
Mr. Chair.
But I know we all struggle with this at the most inopportune times, but let's please try to do that. All right, I want to invite Mr. Carlson to give us his feedback on the 18 amendment. Before that, Senator Westland.
Just very quickly and just for clarification, because there was a lot of stuff flying back and forth over here, and actually Senator Seeberger just said something that made me go back to look at the original language, and the original language actually didn't provide the death benefit. It provided for the disability and the medical costs. And so it seems like this may be something extra that wasn't in the original language that we're amending. Now, we're adding this in here. So I think there's just been, again, we were all shifting papers around, so there may have been some confusion about things. But if you go back to the original A14, delete everything, I don't believe that included a death benefit, and so this language actually does include one. It's more than what you originally had in your original A14 amendment. Mr. Chair.
Senator Westland.
I think there's been some clarity, and I had a moment to speak with Senator Fateh about this and explain the fact that based on his original request, we have taken out the limitation, the weekly limitation on the disability payments, and and so we have met that requirement that he was requesting for the drivers. And the death benefit is actually extra. It's something that was not included in the original request. And so my understanding from the conversation, and I'll let the senator speak, but I think that there was just some lack of clarity between the disability piece and the accidental death piece. But I think, and I'll let the good senator speak for himself, but I think there might be some additional clarity.
Yep.
Senator Fateh.
Thank you, Mr. Chair. Before I speak, I would like to defer to Mr. Cooper first, if that's okay.
Mr. Cooper, and then we're going to go to Mr. Carlson.
Okay. The original bill had dramatically more benefits. It had, on line 2.9, had 500,000 for disability. The amount here is a very, very small fraction of that. It had $1 million for medical costs.
Mr. Cooper, we are familiar with the original bill. Do you have a comment specific to Senator Westland's point?
That is specific, because I think her point was that we didn't have these benefits, and we did. Let me then move to the other issue, which is the issue of the accident language.
Okay, right now, I'm focusing on Senator Westland's comment with regard to the 156 weeks and the death benefit. Do you have anything further to say on that point only, Mr. Cooper?
I was only party to the conversations for part of the time, but had a very different impression. But I'll pass it back to the senator.
Senator Fateh.
Yeah, I spoke with Senator Westland. I agree to the change. I spoke with Senator Westland on the side, and I agree to the change.
What change is being proposed here, Senator Westland?
Mr. Chair, I believe what Senator Fateh means is that the accidental death benefit is extra from what he originally had, and he's in agreement with the accidental death benefit as it's listed in the amendment, to keep it as written. So in other words, Mr. Chair, 1.32 through 2.8, we're good to go.
Senator Seeberger, this is your proposed amendment. Is this consistent with the way you would like the committee to consider the amendment?
With my oral amendments, yes, it is.
Mr. Joel Carlson, what is your position on the proposed A18 amendment?
Thank you, Mr. Chair and members. Appreciate the committee's desire to have a more realistic insurance product in the bill, and we thank you for taking the time to work through this. The amendment that was made on 1.30 to 1.31 is because we don't really have the policy in front of us, and we don't know how long those benefits extend, or if you then are entitled to other disability benefits. We support the amendment, but we have caveats, Mr. Chair, as I told you. This is a large bill that has many moving parts. This is an expensive piece of the bill that is being amended, and it has to work globally, but it's a much better place than where we were, and we do not oppose its adoption.
Do members of the committee have any questions or comments regarding the proposed A18 amendment? Senator Westland.
Mr. Chair, so my life as a lawyer, sometimes this is how it goes. We show up to trial, and we settle cases on the courthouse steps, and oftentimes it's going back and forth and trading language and trying to come up with something that will work for folks. And I know that Senator Fateh has been really invested in the conversations that we've been having and trying to come up with a resolution to the impasse that would benefit the drivers for whom he has brought this bill. As with many things, when you kind of do it like this a little bit on the fly, you know, we have come up with solutions that I think on the insurance piece, I think this addresses it and maybe provides a little bit of an additional benefit that had not originally been anticipated. As I have discussed with the parties previously in the conversations, we didn't reach a global settlement, and I always encourage people to agree to the things you can agree to. And there may be some things that you aren't going to agree to. But I believe Senator Seeberger's amendment is a good amendment. I think it was brought in good faith. I think that it is consistent with our conversations. I think the death benefit is actually an additional benefit over and above what was originally requested in the bill. So I would encourage members to support the amendment. And then if there are other conversations that we need to have, there's been some willingness on the parties to have some additional discussions about this. But to be honest with you, it's 7:30. I think we should get this in the best shape that we can, and I think we should pass this bill.
I would like to know from Senator Fateh if he is accepting the A18 amendment with the alterations that have been made. If he would consider that to be a friendly amendment.
I would accept the changes, but there's also a few locations where the word, oh, sorry, thank you, Mr. Chair. There's also a few,
Senator Fateh.
there's a few locations where the word accidental is inserted.
This is accidental, occupational accident insurance, is it not?
I may defer to Mr. Cooper if that's okay, Mr. Chair.
Mr. Cooper, can you identify specific language that you think is problematic?
I
And
can.
only address that point, please.
I will. It appears, the word accident appears on line 210 in an accident covered. It appears on line 2.2. It appears on line 1.3. And the concern I have is an acute one. If the insurance policy is written to say it only covers accidents like workers' compensation, i.e. you fall down at work or you cut your hand at work or something like that, it will not cover intentional shootings, intentional knifings, intentional beatings. Whoever said we haven't seen the policy is correct, but we've all seen these policies in other settings. And typically, it is not covering protection for intentional acts. I don't see where striking those words would in any way change the thrust of this piece, but it would create significant doubt as to whether it would cover anything. Because don't forget, the car accident insurance already covers accidents. And this is not a duplicate of this. This is for things not covered by car insurance. So the words accidents, I suggest, should be stricken, and I don't see any reason against that.
Mr. Cooper, I caught the first two references you made, line 2.10, line 2.2, and I didn't hear the third one.
2.10, 2.2, and it was also 1.33.
1.33?
Yes.
Now,
Just
Mr. Cooper, this is called occupational accident insurance, and it's listed in the language of the amendment in most of those places as repeating the name of the insurance, which I understand is a term of art in the insurance policy field, a type of insurance called accident or occupational accident insurance. So I don't understand why there's a problem putting the name of the insurance in the body. And I don't understand how it would be helpful to delete the word accident when that's the name of the insurance. Can you
And,
enlighten me?
Yes, I can enlighten you. I had thought in our conversations that it was not going to say, I had pointed out what you just said, that occupational accident insurance has certain specific meaning, and it should say appropriate insurance including possibly occupational accident insurance. And I thought that's what we had agreed to. The important point of that is exactly what you just said, Mr. Chair. It does have a term of art, and that term of art does not include intentional acts. And this insurance is intended for intentional acts.
Mr. Cooper, let me ask the senators if what their understanding was, and if they intended to include intentional acts in the insurance coverage. Senator Seeberger.
Mr. Chair, thank you. When it comes, no, and there is no insurance that covers intentional acts as it relates to the insured, or sometimes a third party. But this speaks to an accidental death would be the result of an act of violence. It is to cover specifically the types of situations that were described earlier on in the process. That's what this is called, that's what it is for. It's an accident, it's a death on the job. I would point out, this was not a part of the terms that we discussed or agreed to, and is yet another moving target. I am satisfied with the shape that this amendment is in. I think it's a great amendment, and I would ask if we can't agree on the terms of the amendment, that I will withdraw my motion and simply move that the entire insurance section be stricken.
Senator Seeberger, you're an insurance expert in many regards because of your professional occupation. Is it your understanding then that if a driver were shot, someone intentionally shot and killed them while they were being an Uber driver or a Lyft driver, that would be covered by the insurance that's proposed in this amendment?
Actually, if they're driving the car, then it would be covered under the 65B 417 piece. If they're outside of the car, I would have to defer to the definitions within the policy of what constitutes an accidental death.
I would assume it would certainly be accidental as to the victim or the driver. I mean, even if the act that caused the death were intentional on the part of the actor. But as I understand insurance, I'm not an expert on it, intentional act exclusions apply to the intentional act of the insured, of the party that would be covered by the insurance, not the cause of the injury in other cases. In other words, if a person committed suicide to get a death benefit to their family, it would be an intentional act on the part of the person who committed suicide, and that would be excluded from coverage. I assume there's a separate exclusion also written in for that specific kind of scenario, but am I illustrating, is the metaphor accurate as you understand it?
Mr. Chair, yes, but there are instances in insurance policies, liability insurance policies, where negligence versus intentional acts are a distinction that is made. I don't know that in the context of death benefit policies, that distinction is actually made.
Okay, but in those other policies, negligence versus intentional, those are liability policies to cover the actor. I'm sorry, to cover the person who is the insured, right? They purchase insurance against their own negligent acts, and then they don't get coverage if their act was intentional instead of negligent. That doesn't even sound like it's a concern in this kind of a scenario here, does it?
Mr. Chair, no.
All right. Mr. Carlson, do you have anything else you'd like to add on this topic before we move toward a vote?
I'm glad I could straighten that out for you, Mr. Chair. You hit the nail on the head. This is insurance that is in the marketplace for accidents that incur while you are doing your activities while performing services on the app, and that's what it covers when it isn't covered by your mandatory auto insurance under 65B.
Do any other members of the committee have any discussion on this? Senator Westland.
Just my quick Google search, Mr. Chair, I do think that I do think that this covers, the whole point of this is it covers incidents that occur while you're on the job. So my passing understanding of this is that if you are injured or you die on the job, that this insurance would cover it.
Senator Seeberger, you agree?
I do.
All right, Senator Seeberger moves the A18 amendment to Senate File 2319. With the amendments, with as she incorporated changes into the A18 amendment, with the instruction to council to make any adjustments to page and line numbers or number and or letter or renumber, reletter paragraphs so that they work. And also, and any other technical changes that need to be made. All those in favor of the amendment, say aye. 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 Opposed? Motion prevails. The amendment is adopted. Okay, members, we now have before us Senate File 2319 that has been amended by our earlier, no, didn't we have a earlier amendment? We had the A17 amendment that adopted it, or amended it, right? And now we have added the A18 amendment, right?
Did we adopt the A14?
No, not the 14. Did the A17, no. Okay, so we have the Senate File 2319 as amended by the A17 amendment and the A18 amendment. We now have before us the A14 amendment, okay, which is now, and the language in the A18 amendment that we just adopted included deleting Section 2 in the A14 amendment. So the rest of the A14 amendment that members have in front of them is intact as of this moment. That leaves Section 1, the definitions, Section 3, minimum compensation, Section 4, deactivation, and the remaining sections in the A14 amendment. Is there any discussion relating, so we're going to have the A14 amendment before us now. Is there any discussion relating to the A14 amendment? Senator Howe.
Thank you, Mr. Chair. And I'm not sure if I want to have this discussion on the A14 or after it's adopted, but I guess where I'm confused a little bit, and I've heard testifier use the language kind of interchangeably, and with the terms employee and contractor. And I guess the reason I bring that up is normally when I contract with someone, which I've both been an employee and a contractor, I guess especially with what we just adopted, insurance piece, that when I'm an employee and I get injured, I got coverage. I got work comp, I got whatever. But when I'm an employee, when I'm a contract, 1099 employee, when I'm a contract person, that usually, whatever I go get insurance, whether I get work comp, that's usually on me. And that really drives home the point with my recent injury to my arm. If I would have been an employee, it would have been one thing. As a contractor, that was on me. I guess with the terms that we've been interchange there, are we talking about these folks as employees, or are we talking about these folks as contractors? Because it
Senator
has
Howe,
been
there-
interchanged there numerous times.
Senator Howe, there is Section 9 of the A14 amendment on page 6 specifically addresses that question by stating that as the intent of these provisions here in the rest of this bill to have no impact on a determination whether they are considered to be independent contractors or employees. So it doesn't take a side and it attempts to explicitly not take a side on that debate.
So, Mr. Chair, thank you. So the definitions that we see in the Department of Labor and Industry would apply to these provisions.
The intent of this language, Senator Howe, is to not take a position with regard to that question.
I find that strange, Mr. Chair. I would think that that would be something that we would definitely address. I think it definitely lays out, when you look at the Department of Labor and Industry and their definitions as far as how this should be treated and how it should work. Without that, I struggle to figure out how this actually is supposed to be enforced if you haven't defined what they actually are.
Before we go on with that, there was one other thing I wanted to ask Senator Fateh or clarify for the record. And I'd had this conversation offline with Senator Fateh while they were discussing the insurance provision. But I want it on the record as well. Senator Fateh, I indicated to you that if we reached an agreement today on this insurance stuff and we put this provision in the bill, that you would agree, or I requested that you would agree to have no further negotiations about the insurance provisions in this bill. It was our intent to try to wrap this piece of it up and be done with it so that it doesn't become the subject of further negotiations over in the other body or between the parties or anything like that. So I'm not saying what position people have to take on the final bill, but as to this provision, we just spent a lot of time, a lot of effort trying to reach as much as we could as a stakeholder agreement on this provision. But I would like to ask you now, do you agree to that?
Thank you, Mr. Chair. When we agreed to that, we agreed to certain languages that was not presented right now. So there has been some modifications. What I agreed to with the senator right now is, for the purpose of everyone's time, agree to this now and work on this offline with all stakeholders.
Okay.
Because
Senator Fateh, I'm going to state this as clearly as I can. I recessed this hearing for, I don't know, an hour?
Yes.
So that the parties could get together with a lot of senators involved, with stakeholders who frankly won't talk to each other because of the bad blood that has developed in the negotiations, with the explicit purpose of trying to find an agreement here. And now you're telling me that there's going to be some quarrel over the language or the name of the insurance that's covered here, and as a consequence, you want to leave open the ability to continue to quarrel and negotiate over this particular provision for the rest of this legislative session? Is that what I'm hearing you say? Because that would not be what you told me offline.
Thank you, Mr. Chair. Yes, I did commit to that on the language that was agreed upon previously, but after consulting with Mr. Cooper, we're good to go for now. No more negotiation on this piece. So
Okay.
we're okay on this now.
Good to go for now is not good enough for me, Senator
Not for
Fateh.
now. I shouldn't have used the word for now.
Good to go until the end of the legislative session. This bill either passes or dies in the legislative process.
Correct. So we're good to go. The insurance piece is settled.
Thank you, Senator Fateh. Senator Kroon, did you have some further conversation?
Thank you, Mr. Chair. This is to Senator Howe's point, and maybe this is more for just how people ultimately want to vote on the underlying bill, so I won't belabor the point because I wanted to get to something specific in the amendment. But I guess to me, this whole thing is bizarre. It's there seems to be a fundamental misunderstanding of what an independent contractor is in this room. I'm kind of at a loss for words on the bigger picture. Seems like people want to have the benefits of being an independent contractor, the flexibility, setting their own schedule, working for two different companies, but they want all the benefits of being an employee. That's the disconnect I think Senator Howe was trying to get at, and I share that perplexity here. But again, that's maybe just for how people choose to view this bill on final passage. Specifically to the A14 amendment, I'm looking at page 4 and the retroactivity piece, 4.1 to 4.5, and I can't get my head around this, how this is workable, or if there's any precedent for this type of thing. It seems to me like there's a whole deactivation part of this bill, which if it becomes law, of course, Uber and Lyft would be subject to. But up until right now, this isn't the law, and they've had every right to deactivate under current law, which wouldn't have all these requirements in it. So how in the world do we expect these companies to be able to go back 4 years and come up with a case as to why they deactivated somebody that wasn't under the law? They had every right to do it without reason, and now we're going to retroactively shoehorn all these reasons and obligations on them for the past 4 years? This just seems nonsensical to me. I cannot believe we're even considering this. And so I know that Mr. Carlson earlier this morning talked about how, I think he said something about how Uber wouldn't necessarily even have the records to go back and comply with this, and I was wondering if he could elaborate on that a little bit more.
Mr. Carlson.
Mr. Chairman and members, the 4-year look back is extremely problematic, whether it's a matter of records or bringing and locating a passenger that was the subject of the reason for a deactivation. And going back now 4 years, we have to give them a full hearing that is required in the deactivation provision. And if we don't do that, they must be reinstated. And so trying to locate the rider, the records, and trying to apply that to these new standards is just an impossible burden that I don't think a driver who has been deactivated can't simply try and reapply without going through all of this mandatory requirement for rules that weren't in place at the time when someone was deactivated. And as I indicated this morning, they're not looking to deactivate these people, these drivers. They want these drivers to work. This is, when you're no longer on the platform, it's for a serious reason. And now to relitigate that now 4 years back is going to be an impossible burden. And I think we'd rather spend our time and attention growing the driver base and trying to address drivers that want to apply and address it at that point. This is a very difficult burden for the companies, whether it's retaining the records, getting the witnesses. It just is, including locating where these drivers are. We have to text them, we have to write to them, and we don't have any records of that. It's going to be extremely burdensome.
Mr. Chair?
Senator Kroon.
Thank you, Mr. Chair. Would it be, Mr. Carlson, would it be safe to say that there could be instances here where drivers in the past 4 years have been deactivated for very legitimate reasons, in fact, reasons that would comply with the proposed new law, public safety reasons, that due to the practical realities of this, you would be in a position to reactivate those drivers under this bill?
Mr. Carlson.
Mr. Chair and Senator Kuhn, that's exactly our point. If you look at line 4.4, they must be reinstated if we can't comply with a proper hearing with witnesses to justify the action that was taken 4 years ago. We must reinstate them on line 4.4.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I have, that is very problematic to me. Maybe there were instances, I mean, who knows, going back 4 years where there were deactivations that wouldn't fit under this new law, but again, those weren't in place at the time. That's the key thing. And just as a matter of fairness, in addition to the practicalities, I don't know how we can go back 4 years and say, this should have been your deactivation process, particularly when there's a public safety issue here, where some of these deactivations were probably for public safety reasons that benefit the public safety, and they're gonna have to reactivate it. So I guess I'm just gonna make a motion here to strike 4.1 to 4.5 in its entirety. Let's go 15?
1.5.
1.5, I'm sorry, 4.1 to 4.15.
Senator Cruin, Ms. Primo, council is recommending through 4.13. Those are the retroactive deactivation provisions.
Thank you, Mr. Chair. My motion will be to strike 4.1 to lines 4.1 to lines 4.13.
So the only question that I have with regard to that is whether any of this would impact the ability of a driver who has previously been deactivated to reapply for driver's status. So then, although if this were to prevail, and they did not have a right to go through a hearing about the prior deactivation, with the burden of proof, as stated here, being on that of the TNC to justify the deactivation, which they may simply be unable to do. What would be the impact on the ability of any driver at any time to reapply for driver's status and to be subject to the screening criteria or eligibility criteria that the TNC applies to any applicant? Senator Cruin.
Thank you, Mr. Chair. Now, I don't know all of Uber and Lyft's policies when they deactivate somebody, what goes with that. I guess I'd have Mr. Carlson speak to that, but simply based on striking this language, I don't think there would be anything that would prevent a deactivated driver from reapplying simply by striking this, unless I'm not aware of some other policy.
Part of what caught my attention is on lines 4.4 and 4.5, there's language that talks about reapplying and the application being reviewed consistent with this chapter. So I'm not quite entirely sure how that line fits in with the deactivation procedures or any of the other parts of the bill. Mr. Cooper, to that point?
Yes, Chairman. The reality is right now that if you've been deactivated, they will not let you reapply. And the reason, the genesis of this section was that we've had people who were deactivated 5 years ago reapply, and it's a blanket rule. They will not let you take an application. So I would not be adverse to just leaving the sentences that say you can reapply and go through the normal process. One other thing I want to point out is the deactivation hearing does not require witnesses. There's nothing that says you have to bring in the complaining party. You just have to present your evidence and listen to what the driver says the evidence is. But that's a different point. I just mentioned it because the senator mentioned it. But the goal of this is that if somebody is deactivated, and independent of what some people may be saying, a lot of these deactivations seem to be very arbitrary and capricious. But once you're deactivated, you're gone. You don't get to come back. So if we left in the second half of the language, which you had the line numbers, but I forget what it is. It's 4.3 through 4.5, starting in the middle of 4.3, we would be satisfied with that.
Starting on line 4.3?
I'm sorry, I threw my glasses on, I probably read wrong. I'm sorry. I meant 4.4.
So, Mr. Cooper, you're saying that you would consider Senator Cruin's amendment a friendly amendment if it did not include deleting the sentence starting on line 4.4, a driver who has previously been deactivated may reapply for driver status, and the application must be reviewed consistent with this chapter.
That is, that is correct.
Mr. Carlson, to that point.
Mr. Chairman, I know we don't want to micromanage how Uber and Lyft run their business, but you need to know that they can reapply right now. Their reapplication process depends on the nature of the offense. If they've been deactivated because their insurance expired, they certainly easily can reapply. If they've been deactivated for a violent offense that no longer allows them to be qualified under the background check requirements that we have in the city of Minneapolis, for example, they can't reapply. And so putting that language in allows everyone to reapply no matter what, then the company would have to go through that process without just rejecting them because we know that they cannot be accepted because they've failed some other qualification. I don't think that reapplying is the problem that is being portrayed, because we want the drivers, we want them to reapply. Some drivers, I know for Lyft and Uber, if a driver has been deactivated for, say, ADA compliance issues, they won't carry service animals. They have training programs to educate them on what the requirements are, and they can be easily reinstated. And so I think we're making more out of this as a legislative issue on something that the companies handle every single day to try and get drivers in the pool.
So, Mr. Carlson, it appears that there is some lack of confidence among the drivers that applications are being evaluated on their merits, and a lack of transparency on the part of Uber that drivers who have been deactivated are actually informed what the reason is for the deactivation so they can correct any problems if there have been. Like, you were deactivated because you don't have insurance, give us proof of current insurance and you'll be reactivated. I'm hearing the drivers aren't even getting that information from the TNCs. And similarly with the dog issue, for example. So what if we have, I mean, there are other provisions in here that talk about transparency, as I understand it, and that address issues of transparency as the basis for deactivation as well, which ought to solve that problem, or the goal is to solve that problem. But it sounds like it would not contradict Uber's policy to explicitly state that a driver who has been deactivated can reapply, and the application must be reviewed consistent with this chapter. We could even think about adding a sentence that says the fact of a previous deactivation alone would not disqualify an applicant. Now, then the analysis would go a step further on Uber's part, I suppose. If the previous deactivation was for commission of a violent crime, then it'd be the previous commission of the violent crime that might disqualify them, but not the fact they had been deactivated in and of itself. Is that something that would work for Uber, Mr. Carlson?
Mr. Chairman, I'm happy to work on that sentence, because we're fine having them reapply. The way the language is set up is just too much, and having them reapply in and of itself is not something that we're objecting to. But I do need to say, much like the debate has been on this bill, there are a lot of things that have been said about the company, like deactivating females and people because they're politically active. Those things are just not true.
No, it happened to me in Seattle.
Sir?
And
I know this is a matter of concern to
I'm not
people,
trying to be
but we're
inflammatory.
not gonna allow that.
I'm not, Mr. Chair. I'm just saying that we can show you the notifications they get. We can
If you wish to have
demonstrate
side conversations, please take
that
them
they-
outside the committee room so we can
that they
hear the
get
testimony.
information, and not trying to be inflammatory at all. But the allegations don't necessarily comport with what is really being communicated. I just wanted to make
Okay,
sure.
I'm going to
that was
make a
clear.
suggestion here to the parties. that there be a sentence added to the language that would be retained in the bill. At the end of line 4.5, add, "The mere fact of a previous deactivation does not disqualify an applicant." And we're not going to spend 20 minutes wordsmithing the proposal. If it's something that needs to be adjusted with a word here or there, that can happen some other day. But trying to thread the needle here to address the concern, because I share the concerns about going back and giving appeal hearings to whoever's been deactivated in the last 4 years as a very unworkable. But we've already have transparency provisions in here, as I understand it. So if an application is denied, or let me ask this, if an application is denied, is there any requirement that the applicant be informed why? In the bill? Someone who's
In the
read
bill, no, I'm sorry.
Mr. Cooper, is there some provision in the bill that says an applicant should be notified as the reason for the denial of an application?
There's nothing in the bill that says that, but that could be a sentence that goes with the sentence you proposed.
Mr. Carlson?
And, Mr. Chairman, we believe that does happen, so I'm not going to object if there's a sentence that says you need to notify them that they failed their background check or their insurance is not up to date. That doesn't even allow them to get on to the application.
Okay, so the TNC shall notify an applicant of the reason for a denial of the application. Is that acceptable language? Mr. Carlson?
Yes, Mr. Chair.
Mr. Cooper?
Yes, it is, I'm sorry. Chair, yes, it is.
Senator Fateh?
Yes, Mr. Chair.
Oh. Senator Howe?
Take a look at line 3.13 and 3.14.
Senator Howe, that applies to deactivation but does not apply to application.
But-
And those relate to the deactivation, right?
But that's exactly what we're talking about, Mr. Chair.
Right,
Is
but it-
making
but it-
sure they get notified of what they're being deactivated for.
Right, and Senator Howe, but the follow-up to that was a concern that if they can reapply, they should at least be told why they're denied if they are denied in a reapplication. So it's kind of independent of the deactivation component. Okay. All right, so Senator Kroon moved the deletion of lines 4.1 to 4.13, so I will ask Senator Kroon if you would agree to modify your motion to exempt from the deletion the sentence on line 4.4, starting with a driver and finishing to the end of line 4.5, and then adding to that the two sentences that I just wrote. And I can read them again if you wish.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. As long as the consistent with this chapter is not part of it, because that would rope in the whole hearing and defeat the purpose of my motion.
Ms. Primo is recommending on line 4.5 that we still delete after the word status, So, and the application must be reviewed consistent with this chapter to accomplish the purposes we're discussing. Senator Kroon, what do you think about that?
So the motion would be amended to delete 4.1 to 4.13 with the exception of on lines 4.4, a driver who has previously been deactivated may reapply for driver status would remain? I'm fine with that.
Yes, the way it would read after, what I'm thinking would happen, after everything else is deleted, you would be left with a driver who has previously been deactivated may reapply for driver status, period. The mere fact of a previous deactivation does not disqualify an applicant, period. The TNC shall notify an applicant of the reason for a denial of the application, period.
Mr. Chair?
Senator Kroon.
Thank you, Mr. Chair. So the reason would be for the reapplication, not the original deactivation.
Correct.
I can get behind that.
Okay. Okay, I'm going to suggest at the end of my last sentence that we add, and give the applicant an opportunity to address the reason for denial. Senator Kroon, is that acceptable to you as the maker of the motion?
Thank you, Mr. Chair. I don't know what address means. I don't know what that means.
To provide supplemental information? Senator Westland.
I'm so sorry. I'm kind of like, let's move this along
Are you
here.
affirming what I have said by
I
saying
think-
correct, or are
I
you
think,
suggesting a different word?
We don't like the word address. Let's use, and the opportunity to correct the reason for the denial.
Then you get into if there was an error. It may not have been an error.
I mean,
I think we leave address. I think it's clear enough to me. Senator Howe's nodding in the affirmative.
Yeah, I mean, it's not what I would do, but I will accept it.
Look, it's not perfect, but we're not going to get perfection here, right? Mr. Carlson, to that
Chairman.
point.
Might I suggest, instead of address, that you put in respond? Because we certainly want to hear their response if they have one. And we allow that. There's some things you can't address, a background check or something, but they should have a chance to respond.
Senator Kroon, respond okay?
Yes, Mr. Chair. I like
Senator
that.
Fateh.
Yeah. Yes. Yes, Mr. Chair.
Okay, so does everyone know what the amendment is that's before us? Do I need to reread anything? Okay, Senator Kroon is moving that lines 4.1 to 4.13 be deleted with the exception of the language on line 4.4, starting with a driver, and going over to line 4.5, ending with the word status, period. And then the additional language that would be added at that point is the following: the mere fact of a previous deactivation does not disqualify an applicant, period. The TNC shall notify an applicant of the reason for a denial of the application and give the applicant an opportunity to respond to the reason for denial. Senator Kroon makes that motion. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment's adopted. All right, any other discussion on the A14? Senator Kroon.
Thank you, Mr. Chair. The portion, I'm trying to find it here, where, oh, here it is. Page 2, lines 25 and 26. This is the portion where the contractor is going to be compensated on the way to pick up a rider if it's more than 5 miles. I'm struggling with this provision as well, based on my understanding of how this works. The driver would know where it is, how many miles it is, what the pay is going to be, and has completely the voluntary choice to accept it or not accept it. I don't know why this would be necessary in that environment, but if I'm misstating anything, maybe Mr. Carlson can correct me, but am I correct, Mr. Carlson, that all of this information would be known to the driver before they choose to voluntarily accept that ride?
Mr. Carlson.
Mr. Chairman,
Carlson.
Senator Kroon, yes. When they accept a ride, they know the distance, the fare that they will receive before they accept the ride. I'm unaware of any place in the country that pays the fee that is described on 2.25 and 2.26.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. I just think that this is incredible micromanaging of a company's policy when the drivers are not being forced to do this. I think the example was if they're in Minneapolis to drive to pick up to somebody at Shoreview, they could just not do that. And it just seems to be micromanaging how that's done. So, I mean, I would move to strike 2.25 and 2.26.
Senator Kroon moves to strike the language on lines 2.25 and 2.26. Senator Fateh, what is your position on the proposed amendment?
I would disagree. I would urge, thank you, Mr. Chair. I would urge my colleagues to vote no. What I understand is that the TNCs actually charge the customers for the time the driver is going to pick up the customer. And while they're charging the customer that, the driver doesn't see a penny of that. But I'll let Mr. Cooper also elaborate on that if that's possible.
Before we do that, let's ask Mr. Carlson to clarify the factual basis here based on what you just stated, Senator Fateh. Mr. Carlson?
Mr. Chairman and members, Mr. Cooper raised this at a meeting I was at last Friday, and that just doesn't happen. I did confirm it with the companies. I've represented this firm since 2012. They do not charge the passenger for that distance to go and get them. That just doesn't happen. And so I think striking that sentence puts some balance back into this bill. There's a way to stay 5 miles away from where you know the rides are, too. We think this is an unfair provision that we think just increases the rides, the cost of the rides for passengers, and we do need to think about the riders as well. And so we would welcome having this provision removed.
I will confess I was pretty unhappy to hear the prospect that I was being charged as a rider for the time and mileage it took for a driver to come get me in the first place. And I certainly would never agree to hire a company that would do that, because I have no idea where someone's coming from to get me, and I've had drivers change 2 or 3 times on me after I've been told they were on their way. So I would never hire a company that started charging me before I was picked up. But we have on the record now that that doesn't happen. Mr. Cooper?
At that meeting, I'm sorry, Mr. Chairman, at that meeting that he referred to, drivers showed their cell phones that showed the difference in the bill as to how far away they came from. And it included that, and some of the representatives who were in that meeting were talking about, they had wondered why sometimes when they went from one place to another, I'm going to make the numbers up because I don't remember them, but it was $20, and other times they went from one place to that exact same location, it was $30. What we also know, as Senator Fateh said, this is true, they give this to the drivers in Seattle, as well as several other cities, I believe Las Vegas is one of them. The reality is that, in fact, the drivers don't get anything at all, and don't forget who's putting in the time. The driver has to drive there, the driver has to drive his car there, the driver has to drive up to cast his or her car to get there. So the information I have from the drivers who are directly aware of the information is that this does happen, and in the meeting that we were in, they showed it on their cell phones.
All right, well, I'm not going to get into a big back and forth here over that, except it may have more to do with the compensation arrangements that the TNCs have with the drivers and less to do with charging the riders specifically for that empty time. What we have in front of us is a proposal to delete the empty time driving compensation from us. Mr. Carlson, to that specific point.
Mr. Chairman, that is not the requirement in the state of Washington. They do not pay that. That's just wrong information, and I'm unaware of it being charged or collected by a driver anywhere in the country. And I think it is unfair to the passenger, and I think it's unfair to the companies.
But the way this is written, the passenger would pick up that cost, right? Or it certainly would get embedded in the rates that are quoted to the passengers in some way. Mr. Cooper, is that correct?
I'm not sure if that's correct, but I was going to propose or the senator mentioned to me to propose language so that we don't have to argue back and forth. It merely says, if the TNC charges for the empty time, then the driver gets. So if in fact, whatever side is right, gets the benefit of the language and we don't have to argue about it. As far as he changed Seattle to the state of Washington, the state of Washington has one set of rules, Seattle has another set of rules. I wasn't saying it was in the state of Washington, I was saying it was in the city of Seattle.
Senator Westland, to this point.
Thank you, Mr. Chair. It's my understanding, and I'm looking at an article entitled, "Uber will now charge you extra if your driver has to travel longer to reach you." And I think that's what we're talking about. Senator Fateh or Mr. Cooper, is this what's known as, let's see what it talks about here, that there's some additional fee that gets charged for distances after 8 or 11 minutes of driving to pick up the rider? Is that what this is talking about?
Yes, I'm sorry, Mr.
Mr.
Chairman.
Cooper.
Senator, yes.
So, Mr. Chair, I
Senator
think
Westland.
it's called a long pickup premium. Is that correct?
Mr. Cooper.
Chairman, Senator, yes.
Senator
And
Westland.
Mr. Chair and Mr. Cooper, is this what you're saying? So are there some locations around the country where this amount is shared with the driver?
Yes.
Mr. Cooper.
Oh, I'm sorry, I apologize. Mr. Chair, Senator, yes.
Senator Westland.
Gets very confusing, Mr. Chair and Mr. Cooper. And so what you're,
Speak slowly enough for the transcription.
I know, sorry.
The court reporter.
Give me another Diet Coke.
Court reporter can't keep up. Senator Westland.
So, Mr. Chair and Mr. Cooper, so what you're suggesting, and I think the language that you're offering, is that if in fact that long pickup premium is charged to a customer, that the driver would share in that fee. Is that what your proposal is, Mr. Cooper?
Yes, it is, and we put specific figures in here that are much lower figures than they otherwise would get if somebody was actually in the vehicle. But yes, but you said, oh, Mr. Chair, yes.
Senator Westland.
I have no further questions.
Senator Cruin, your witness.
Thank you, Mr. Chair.
Mr. Cooper addressed me as Your Honor earlier today. Might as well play the part. Senator Kroon.
The purpose of my amendment, I don't know whether or not there's the premium or what Uber charges, whatever. My point is that this is all voluntary activity. And so I don't know why we're legislating the companies to, in that kind of detail, to do something that the independent contractor has absolutely no obligation to do. That was my point. I don't know what they charge, and I don't know if it's fair as a matter of contract, if they're charging some premium, whether or not they should share that with their driver. That's what free people do when they contract. I just don't understand why we're micromanaging as legislators, telling a company they shall do this. I could see if this were an employee and they had no choice, that was part of their job, they had to do it, or if it was part of their contract that they had to pick up these people within a certain mile mark over 5, but that's not the case. I haven't heard anybody argue to the contrary to that. So regardless of whether or not they charge the customer, I don't think this should be in legislation.
Senator Westland.
Thank you, Mr. Chair, and I would respectfully disagree with this on a couple of points, and I would actually ask another question of Senator Fateh or Mr. Cooper. If a driver rejects a certain number of rides, is there a consequence for that?
Mr. Chair.
Cooper.
Senator, yes, there is. There's what's called driver ratings of drivers, and your driver rating goes up and down based upon whether you refuse rides. And if it goes down low enough, we believe you're deactivated for that. But we're not told that specifically.
Thank you,
Senator Westland.
Mr. Chair. So from my perspective, Mr. Chair, here's what I would say. We have a number of folks who are doing a job that some people would deem essential. They're doing a job that they're just trying to make a living for their families. And I think what they're asking here is that if the company is in fact earning a fee off of their work for this empty ride, that I think that those drivers should be entitled to a cut of that. To me, this is about equity, it's about fairness, it is about making sure that folks who are in a less strong position to bargain are going to be treated fairly. And I think that this bill is before us today because there are a lot of folks out there who feel that they have not been treated fairly, that they have not been compensated fairly, that their compensation has actually gone down over time. And I think that Mr. Cooper and Senator Fateh have offered a reasonable amendment here to say that this fee will be split if it's incurred. We're asking the drivers to pick up an awful lot of costs that eat into their ability to make a living. And there's a lot of people who aren't doing this simply because they're a student who wants to make a few extra dollars. They're doing this because this is the way they support their families. I'm just going to look around the room, Mr. Chair, too, and I know that we have a lot of new Americans and folks who are using this as their income and their way to support their family. And I think what they're asking for is fair. I think it's reasonable, and I oppose this amendment, and I would ask everyone to vote against it.
I'm going to. Mr. Carlson.
Mr. Chairman, if Mr. Cooper has suggested adding on line 2.26 at the end of pickup, if a fee is charged to the rider, I think, we can accept that. We don't think it's happening, and so if that's added, then I think we can just move on.
Mr. Cooper, would you like to restate your suggested amendment?
I would.
Actually, before we do that, I hate to break this up, but I'm going to ask this of the people in the room. My understanding is that the fifth call to prayer, if I got it right, Maghrib, is at 8:29 today, this evening? I'm sorry? 8:30, so right now? Can I just see a show of hands, how many people that would be a concern for? And can someone tell me, how long do you think it would be, so I can? 15 minutes. 10 to 15 minutes? Okay, we are going to take a 15-minute recess right now, so that, and you can use whatever space you wish to do so, and then we will return.
Mr.
We are in
Chair,
recess.
can I make a suggestion?
Yes.
Instead of sitting here and negotiating during committee time,
Committee's in recess.
Thank back in order. We, as much order as we possibly can be in this. All right, the parties have been working on a number of things. We don't have everything resolved, but we do have a way to move forward. With regard to the amendment that was before us at the moment, that we took a recess for Margaret. I hope I pronounced that correctly. So we have Senator Cruin's amendment to delete lines 2.25 and 2.26. We have some language suggestions to modify those lines. It's my understanding that Senator Cruin is going to consider that language to be friendly and will modify his amendment accordingly. So I think Senator Westland has the language, so I'm going to ask Senator Westland to read the proposed change in the language around 2.25 and 2.26. Senator Westland.
Thank you, Mr.
And I'll
Chair.
turn my mic on. I hope the recording picked up something of what I just said. Senator Westland.
It heard wah, 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 wah. Okay. So 2.25 shall read, a $1.25 per mile and 10 cent per minute fee if TNC charges a fee for long pickup, period. And then delete the words while driving empty to pick up a rider if it is more than 5 miles. And then the rest of it remains the same. I will say.
Senator Westland, could you
Yes.
read that once again for
Yes.
council to make sure they have it down?
And I will try to speak more slowly. A $1.25 per mile and 10 cent per minute fee if the TNC charges a fee for long pickup, period. Delete the words while driving empty to pick up a rider if it is more than 5 miles. And then the fee reverts, stays in.
Do you have it? Okay. Senator Cruin.
I'll accept that as a friendly amendment to my amendment.
Okay. Senator Fateh, chief author of the bill. What is your position on this proposed amendment?
Thank you, Mr. Chair. I support it.
Mr. Carlson, what is your position on behalf of Uber?
Mr. Chairman, with my standing concern about the fees that are in here, I accept the language that has been proposed. I'm not saying yes to 125 or the minute charge, but the language, if there's a charge for a long pickup, I understand that and accept that.
All right. And do you also speak on behalf of Mr. Carlson too, or let's get this down? Mr. Carlson too, on behalf of Lyft, is indicating his assent to this amendment as well, I assume with the same caveat with regard to the dollar amounts and so on that are in there. Okay. Is there any further discussion on Senator Cruin's amendment? Seeing none, all those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. All right, members, we have been trying to get some
Chair?
agreement. I'm sorry.
Was
Senator
that an
Cruin.
amendment to the amendment? And do we still have the underlying amendment as amended to
I
approve?
treated that as you incorporating it into your
Perfect.
amendment.
As long as we're good.
Are we good, Ms. Primo? Okay, no, we have, so we have now amended language on the A14 amendment. Members, we have been, some of us have been working diligently to try to find some language on the deactivation provisions. That has not been successful tonight. So that is going to continue to be a work in progress, but what we will have before us for a decision is going to be the A14 amendment without any changes to the deactivation provision, other than the parts that we amended earlier at the top of page 4. Is there any further discussion with regard to the A14 amendment in its current shape? Senator Cruin.
Thank you, Mr. Chair. I do have several other concerns. I'm not going to offer any more amendments tonight. but just would like to point out that under the transparency section, there's several concerning language which I could potentially follow up with at some future time, but just wanted to make that comment, but I'm not going to offer any amendments.
Senator Crewen, thank you for that, and we had a little conversation offline as well, that you indicated you had some concerns about language, and you are a careful scribe and lawyer, and I indicated that we welcome, and I will encourage the parties involved in this bill to welcome, if you are willing and interested and have the time to participate in drafting changes to this. I encourage you to be involved in that. And I'll indicate my preference that those conversations happen before we get to the floor, because being Judiciary Committee on the Senate floor is a difficult and sometimes very challenging role to play, not only for us, but it tends to aggravate every other member of the Senate on both sides of the aisle. And it's an imperfect way to solve difficult drafting problems as well. So I would strongly encourage you to be involved before this matter comes to the Senate floor, so we can avoid those lengthy floor hearings. Are there any other members wish to comment on the A14 amendment? Okay, so the members we have before us, the appropriate motion would be to adopt the A14 amendment as amended to Senate File 2319 as amended. And then we would have before us the final form of Senate File 2319 for consideration by this committee tonight.
So moved.
Senator Wiklund makes that motion. Senator Wiklund moves the adoption of the A14 amendment as amended with the additional instruction to council to make general clarifying technical changes so that it all fits into the bill. All those in favor say aye. Aye. Opposed? No. Motion prevails. The amendment is adopted. Members, we now have before us Senate File 2319 as amended. Is there any further discussion on Senate File 2319 as amended? Okay. Before we go to a vote, I'm going to say that we have done a lot of work here in the Judiciary Committee today, since 8:30 this morning. There's been a lot of work by members of the committee, by members of the community, and by the parties and the stakeholders directly involved in this bill. I still have some concerns about the way the bill is written and some of the substantive content of the bill. I am not yet convinced that this should become law. I'm going to be willing to vote in favor of a motion to pass it out of this committee without recommendation to the Senate floor. I will tell you now that that is not a signal of what I will do on the Senate floor in terms of a vote yea or nay on this bill. I can only speak for myself. But we have a commitment from the chief author with regard to the insurance provisions. But I will tell you, if this bill comes back, it comes before the Senate floor with any proposals for substantial amendments that change the purpose and intent and most of the language with regard to the work that we have done in committee here today. I'm not talking about the stuff that we haven't specifically addressed with amendments and trying to come to some agreement. But if it comes back onto the floor and there are suggested changes to the insurance provisions or the provision that we just finished amending, or what we did with our A17 amendment, as well as the A18 amendment on insurance, I'm likely to not vote for the bill on the Senate floor. So I would view that as a moving backwards compared to the work we have done in Judiciary today. So I'm just telling the world where I am on this. And I don't know where I will be in a final vote on the Senate floor. There's still some changes I would make, I would prefer, and we're not going to deal with those tonight. But I've prepared to move it along in the process. People know, who've been watching this committee, that I really do not like to pass bills out of this committee that I think, anyway, are not ready to become law, certainly with regard to the content that's within this committee's jurisdiction, but also beyond that to the extent that we have control over that part of the process. Right now, I don't think this language is ready to become law, because it means a lot when we create a statute in Minnesota. So I'm not ready to vote for this on the Senate floor, but I am ready to move it to the Senate floor. And we'll see what condition it is in when it comes up before the Senate floor as a whole, and we'll take it one step at a time. So, Senator Westland, did you have a motion?
Yes, Mr. Chair. I believe we are moving Senate File 2319 as amended to the floor
Without recommendation?
without recommendations.
Okay. So, before we take that, is there anyone else wishes to make any final comments on this bill? Senator Westland.
Very briefly, just to echo a little bit of what Senator Latt says, one of the things that annoys me more than anything is wasting time. We made a lot of progress today, and my irritation is that's progress that could have been made outside of this committee room long before today. And I am offering my time to try to help and address in particular the section on deactivation, because my understanding that's the only thing I'm interested in working on at this point, and I intend to support the rest of the bill as it's drafted. I have offered you my help. I have limited time. Do not waste my time further. Please come to me with language that you're each proposing. You come with a proposal. I would be more than happy to try to help and get this over the finish line, because this is really important. And I support the overall intent of this bill, but let's make it the best thing we can so that when we go to the floor, we have one amendment that we're going to offer to this bill to try and get it into the shape that's decent. And I understand, Mr. Carlson and Mr. Carlson, there's parts of this around compensation that you have noted your continuing objection to. I support the compensation provisions. So let's get this done, get in touch with my LA. I'm going to put only as much effort into this as you put into it and not one bit more.
Senator Uma Verbeten.
Thank you, Mr. Chair. I just want to acknowledge that we've had folks that have been here all day and thank them for sticking it out. And just, I guess, reminder that, we'll take the vote and then we'll adjourn, and then, if things go the way that folks hope they do and are excited, just to kind of hold that until we're done with the committee. But really appreciate everyone being here and taking time out of their day and their work schedule to be with us. I know that's really difficult, and we really appreciate it.
And once we're done with this vote, I'll have a couple of procedural announcements. So if we can keep the room quiet so we can conclude the business of the committee, appreciate that. Senator Limmer.
Thank you, Mr. Chairman. During this time that we've deliberated on this particular bill, I remember one of my first comments this morning was whether or not the state is interfering in contractual agreements between parties, and I'm still concerned about that. There's other examples that we have considered as a legislature as well. I don't think that really serves a free market well. I understand the conditions that we discussed all day, but I'm very concerned about the direction of where the legislature is beginning to go as a pattern of behavior. We are not a judge and jury. We are a legislative body that makes policies for the state. And if there's disputes, then this is not the best place to resolve those. So having said that, Mr. Chair, I'm very cautious about this bill, as you are. Thank you, for a different reason.
Any other discussion from members of the committee? Senator Kroon.
Thank you, Mr. Chair. I'd just like to echo Senator Limmer's comments. I do have deep philosophical issues with this bill, but I also have practical problems with the bill and the way it's drafted, as I've mentioned. So for me, it's twofold. It's not workable. The language is sloppy. It doesn't work together. It's ambiguous in places. And then there's my philosophical issue as well. So I just wanted to add that. Thank you.
And sometimes we put time into work on bills, even if we don't like what they're doing, but we feel it's important to make them workable if they are going to become law. I spent 6 years as a Democratic lead on this committee, doing that kind of work, even where I didn't necessarily like where a bill was going. I was trying to make sure it was workable, anticipating that it might become law, and it needed to work well when it did. So I'd welcome the input of committee members to that end as well. Senator Wiklund moves that Senate File 2319 as amended be passed without recommendation to the Senate floor, and that direction be given to council to make technical and other related changes to the bill as deemed necessary. All those in favor say aye. Aye. Opposed? No. The motion prevails.
No.
Senator Eichmann.
The motion prevails. Now, we are concluded now with Senate File 2319. Members, I'm not aware of any other bills that we will be asked to consider before the end of session. Honestly, I was not anticipating these either. But it is possible that we will be asked to do so, and we'll let you know if we do. In the event that this is, in fact, the last committee hearing for this spring, I just want to make sure I express on the record my appreciation to our incredible staff on both sides of the aisle and to our members that have worked hard in this committee, and to all those who have come to participate and observe in the work of this committee. We take our work here very seriously, as you can tell. We're doing our best to create good work product on behalf of the people of Minnesota and the constituents that we represent. So my appreciation to all of you who have worked so hard to make this committee work so well. And with that, we are adjourned.
Thank you. Thank you.